Aloha mai kako, good morning. This is the October 8th, 2020 Land Use Commission meeting, which is being held using interactive conference technology, linking video conference participants and other interested individuals of the public via the Zoom internet conferencing program. We're doing this in order to comply with state and county official operational directives during the COVID-19 pandemic. Members of the public are viewing the meeting via the Zoom webinar platform. For all meeting participants, I would like to stress the importance of speaking slowly, clearly, directly into your microphone. And before speaking, try to remember, particularly if you are in a room with multiple people, to identify yourself prior to speaking. Please also be aware that all meeting participants are being recorded on the digital record of this Zoom meeting. Your continued participation is your implied consent to be part of the public record of this event. If you do not wish to be part of the public record, you should exit the meeting now. This conferencing technology allows the parties and each participating commissioner individual remote access to the meeting proceedings via our own personal digital devices. Please note, as we experienced yesterday, due to matters entirely outside of our control, occasionally disruptions to connectivity may occur for one or more members of the meeting at any given time. If such disruptions occur, please let us know, and please be patient as we try to restore the audiovisual signals to effectively conduct business during the pandemic. My name is Jonathan Lee K.K. Scheuer, and I currently have the pleasure of serving as the LUC chair. Along with me, Commissioners Axon, Chang, Okuda, and Wong, our LUC Executive Officer, Daniel Oradinker, our Chief Planner, Scott Derrickson, our Chief Clerk, Riley Hakoda, our Deputy Attorney General, Colin Lau, and our court reporter, Jean McManus, are on the island of Oahu. Commissioner Cabral is on Hawaii Island. Commissioner Giovanni is on Kauai. Commissioner Ohigashi is on Maui, but is joining our meeting at approximately 10:30 a.m. due to a schedule conflict, and Commissioner Giovanni will have to leave at 10 a.m. We currently have 8 seated commissioners out of a possible 9. If you recall yesterday, I made an exception at the request of an individual witness to continue his cross-examination on the HALEKUA Development Corporation matter, docket number A92-683. We will have no more than 1 half-hour of questioning of Mr. Jeff Overton on cross-examination and any necessary redirect. We will then proceed to our agenda as previously planned, starting with the adoption of the order on Hawaiian Memorial Life Plan, followed by taking up the special permit on the County of Maui Central Landfill, and then we will return to the HALEKUA development matter. If we have not insufficient time today to complete all our matters, it will likely be the HALEKUA matter that will not be completed. Are there any questions on our proceedings from the commissioners? If not, let's admit Mr. Overton into the room. And we were at the point in the proceeding where Haseko was cross-examining Mr. Overton. Again, we have a tight schedule. I hope that the questions and responses will be brief and relevant to the proceedings that we have before us. Mr. Overton, you're still under oath. Please proceed.
Good morning, Chair.
Haseko.
Thank you. Thank you so much for accommodating the schedule yesterday. I appreciate that.
Good morning, Chair, Commissioner members. Mr. Overton, this is Stephen Chung. I am the co-counsel for Haseko Royal Kunia. So let's pick up where we left off yesterday. We were talking about the drainage master plan, but backing up, just setting the stage for my questions. It is 157,000 out of 161, I'm sorry, I misspoke. 157 acres out of 161 acres of parcel 52 that is proposed for installation of solar panels. Is that correct?
I'd have to double check the acreage, but that sounds approximately correct.
That's approximately 97 to 98% of the entire parcel 52 area.
That's not the exact lot coverage percentage. That's the acreage of the project area less easement setbacks and such.
Would I be correct in assuming that the project will extend up to the setback area?
In most cases, it will.
Okay. And so solar panels could be placed all the way up to the setback areas?
As allowed by the city.
And that would include the area that was designated for the detention basin?
Well, in 2015, the commission approved the solar project. And the solar project was, at that time, as it is now, responsible for drainage on their own property. So they're really just refreshing the project to the 2020 design. But to the best of my knowledge, there's no drainage easement affecting parcel 52. And so the same conditions are applied to the current solar farm, and the drainage system for this farm must be sufficient for the current proposed solar.
So do you recall yesterday that we talked about condition 16 of the 1996 amended decision and order?
I know there's discussion on that, but I really don't know the answer to that question. I do planning and permitting work. I don't do civil engineering. I don't do legal interpretation of conditions on that. So I was aware that there was a condition that, with the city, we have to go through the drainage ordinance to satisfy that for the grading approval. And all of that was known by the LUC at the time of the 2015 approval. And then the subsequent conditional use permit that was approved. So the city's been all through it and the drainage was satisfied.
Okay, please listen to my question. I'm just specifically asking questions with respect to condition 16. Is that okay?
This is John Minot for Ohana. I'd like to object. This is outside the scope of his written direct testimony. He's already answered the question to the best of his ability, and it's becoming argumentative.
Mr. Chung, can you enlighten us as to the purpose of your questions?
My question, Mr. Chair, is I'm going to ask Mr. Overton if the Ohana move on is requesting a modification or deletion of condition 16.
That particular question is allowable, and the witness may answer that it's outside of his ability to answer because it's outside his expertise.
Mr. Overton, are you able to answer the question?
It's really outside my expertise.
So you're not able to answer the question?
That's correct.
Do you know whether or not the impact of drainage on neighboring properties was discussed in the move-on's motion?
In the current action that's before the commission, was
That's
drainage
correct.
addressed?
That is correct.
To the extent that we need to meet state and really county standards. That comes out really with design that comes in the future. But we have to meet those standards, and there's a requirement for on-site drainage control.
I'm just asking you whether the move-on addressed the impact on the neighboring parcels in its motion.
I believe the witness has answered the question.
Thank you. In the motion that was filed with the commission, did the move-on address the impact of the project on the neighboring view planes?
As was presented in my testimony yesterday, we showed some very specific examples of existing and future views. So yes, it's been addressed.
That was addressed in response to the objection that my client filed, wasn't it?
I know that for our submittals, we need to provide adequate view analysis. It's a requirement for solar farm applications. And just as we had done in 2015, we updated that study to reflect the new proposed solar farm. And we actually took a closer look at the HALEKUA property, and I went through dimensions, distances, as well as the buffer proposal.
So the landscape proposal that you discussed yesterday, was that included in the original motion?
Jack, this is getting irrelevant and already asked and answered yesterday.
I am having a hard time, again, Mr. Chung. I want to allow you to cross-examine the witness that the petitioner chose to call, but I need to understand the relevance to your overall point.
Well, the relevance, Mr. Chair, is that these matters were not discussed in the motion that was filed,
They were discussed yesterday.
but they were not discussed in the motion. Mr. Chair, I have no further questions.
Thank you. City and County, do you have any questions for Mr. Overton? Make your way up to the mic.
Sorry, you can see me. This is, for the record, Eugene Takahashi, Second Deputy Director, Department of Planning Permitting, City and County of Honolulu. We have no questions.
Great, thank you. Ms. Apuna,
No questions.
commissioners, do you have any questions for Mr. Overton? Are there any questions for Mr. Overton, commissioners? Commissioner Cabral.
Yeah, thank you. I have to figure out where the hand motions are on that. Mr. Overton, thank you very much for testifying with us. I appreciate the perspective. In your opinion, and based on the photos that we saw yesterday, with what I'm assuming the growth that is in place now is weeds, for lack of a better description. I'm not familiar with the terrain. I mean, I've been there, we've been there, but I'm not, from Hilo, trust me, you wouldn't see anything. The trees would be 50 feet tall in about 2 years. But with that kind of growth, and the representation was that there will be no visual view of the solar panels that will start at 6 feet high. The fence was going to be slightly higher. But is there any plans with what you've put together to put any kind of additional barrier? And the fence is going to be there, and you're going to have a hedge or something. But is there any possibility of having larger trees that would potentially help stop any kind of view from anywhere on the neighboring properties, but without blocking the effectiveness of the PV panels? I don't know what that possibility is in that terrain.
Yeah, Derek Simon may be able to pull up the view projection that we did at this edge, Commissioner Cabral. And to answer your question, one of the concerns that we've worked with the city on appropriate vegetation buffers on all the solar projects that we've worked on. They can't get too tall because it shades the solar panels, and you also introduce debris and things like that. So we try to keep a good growth that exists along that edge. But as you can see here in this depiction, this is the finished situation. So the fence line is kind of faintly seen here, and then this growth is roughly about a 7-foot intersection. And you can see some of the existing vegetation here, which is roughly California guinea grass and HALEKUA and other invasive species that exist out there today. I hope that answers your question.
Well, yeah, okay, this is the photos we saw yesterday. The guinea grass and that we're seeing in the forefront of the photo, that's from a neighboring property, and we're looking at the hedge. Is that the hedge that's already in place? And if it does look like there's a line there, so is there an actual fence already in place there?
Not yet. It'll be constructed as part of the solar project. So we're standing on lot 51, or parcel 51, which is the HASECO piece, and looking out at the solar farm at grade here, as you would from street view. And this gives you an idea of how the future solar farm would be viewed. Now you're going to have landscape, of course, within the individual residential lots. So I think that in itself will be shielding.
Okay, that's really my real question is, if there are residential lots abutting to that area, is there anything that you can project that with a 6-foot high solar project that would be potentially unpleasant, or there's not a lot of noise, I assume, not from my solar panels, but is there anything that could be disruptive to a neighboring lot owner, a neighboring resident living there, a neighboring commercial property? Is there anything that you are aware of that is something that would make the adjacent lots?
Sure. Your question really, there's no noise. Of course, these are tracking panels, which is great because what it allows is the glare condition, which might exist if you were flying by in a drone or a plane, then you might at times on a fixed panel system have a glare condition, but with tracking, it varies throughout the day. And there, you would not see glare at ground level here at all. So it's more up in a bird's eye view where you could potentially have that. But no glare conditions here, no noxious odors or noise.
Okay. Okay, great. Thank you very much.
Okay, if you can take off the share screen, Mr. Simon. Is there anything further, commissioners? Any redirect, Ms. Commissioner Axon.
Not a question, but I just want to thank Mr. Overton for coming back today, and I want to wish you a happy anniversary.
Oh, thank you very much. I have a very patient and understanding wife. We'll make 35 years if I get to 4 o'clock. So I really appreciate it, Jonathan, Chair, and the commissioners, your flexibility here. Really appreciate that.
I guess I will establish for the record at this time on September 9th, I chaired a LUC commission meeting, and it was my 20th anniversary. So,
Awesome.
Any redirect, Ms. Lim?
No redirect. Thank you.
Okay, Mr. Overton, you are dismissed for fun and games in Cape Cod.
Thank you very much. Aloha, everyone. See you soon.
Okay. Commissioners, we're now going to, as I indicated earlier, hold off on further proceedings on this docket and move on to adoption of the form of the order for Hawaiian Memorial Life Plan. So if you are counsel for this particular thing, you can step, at least turn your video off, and we will admit the parties for docket number A17804.
There you go.
City and County of Honolulu again. Hawaiian Memorial Life Plan Limited Petitioner, Intervenor, Huio Pikoiloa, Office Planning.
Sorry, we had an audio glitch. The question is if you have any questions?
No, we're about to start the proceedings on adoption of the form of the order for Hawaiian Memorial Life Plan. I was noting who the parties were.
Oh, I'm sorry. Okay, for the record,
Hold off.
okay.
Mr. Hakoda or Mr. Derrickson, do we expect the interveners to be here?
Now you can talk.
Thank you, Mr. Chair. Intervenor has indicated that they will be present today.
Sorry, you broke up at the very moment of the critical word. Will or will not?
Has indicated that they will not be present today.
Got it. Okay, then let's get going. Our next order of business is adopting the form of the order on docket number A17804, Hawaiian Memorial Life Plan Limited, a petition to amend the Conservation Land Use District boundary into the Urban Land Use District for approximately 53.449 acres of land at Kaneohe, Island of Oahu, State of Hawaii, TMK number 14-5033, a portion of Lot 1. Mr. Hakoda or Mr. Derrickson, has there been any written testimony submitted on the adoption of the order in this matter?
Mr. Chair, this is Riley. No testimony has been received.
Okay. Are there any members of the public who wish to testify on this matter? If so, please use the raise hand function and indicate you're willing to, or your desire to testify now. Seeing none. Can we have appearances on this matter?
Good morning, Chair, members of the Commission, Curtis Tabata and Benjamin Matsubara for Hawaiian Memorial.
Good morning, Mr. Tabata. City and County.
Go ahead. Oh, okay. For the record, City and County of Honolulu, Department of Planning Permitting, Second Deputy Eugene Takahashi. With me is Molly Stebbins from our Office of Corporation Counsel.
Thank you.
Morning, Chair, Commissioners, Deputy Attorney General Donna Puna on behalf of the State Office of Planning.
Thank you. Before we take any motion up, the chair would like to confirm for the record that all commissioners and myself are prepared to participate in these proceedings. Commissioner Chang.
Yes, I am prepared, Mr. Chair.
Thank you. Commissioner Axon.
Yes.
Yes, you said. Commissioner Cabral.
Yes, I am.
Commissioner Okuda.
Yes, I am.
Commissioner Wong.
Yes.
Commissioner Giovanni.
Yes.
The chair is also prepared to participate. The commission will now consider adoption of the order. Commissioners, before you, for your consideration, deliberation, and adoption are the proposed findings of fact, conclusions of law, and decision in order prepared by staff as instructed at the last meeting on this docket. Is there any discussion? Commissioner Axon, followed by Commissioner Okuda.
Mr. Chair, are we in discussion or you need a motion?
We can be, the plan was to be in discussion and then entertain a motion, but we could also do it, take a motion and then do discussion.
Okay, well, I want to make a motion. Is that okay, Mr. Chair?
You may proceed.
Yeah, I move that the commission approve and adopt the final form of the decision and order for 817-804 Hawaiian Memorial Life Plan Limited.
Is there a second?
Chair, this is Commissioner Wong. I'll second.
A motion to adopt the form of the order before us has been made and seconded. I'm now going to recognize Commissioner Okuda.
Thank you very much, Mr. Chair. I first have a clerical question. What are the total number of commissioners present right now today at this moment?
7.
7. Oh, okay. Thank you. I would, I know my vote is already on record, but I would ask that one sentence be added to the order at page 153. The one sentence would follow a sentence, and if I can read that sentence, that my proposed sentence would follow. The order now, proposed order now reads, a copy of the recorded conservation easement and declaration of restrictive covenant shall be submitted to the City and County of Honolulu Department of Planning and Permitting, quote, DPP, close quote, prior to the issuance of any grading permit or any other permit which involves ground disturbance. I would propose that the order add the following sentence to read as follows. Petitioner shall also execute the agreement with the Ko'olaupoko Hawaiian Civic Club containing all provisions consistent with the petitioner's representations before any work involving ground disturbance. And that's my only request, Mr. Chair.
Okay, so a request is made to the movant and to the seconder to amend the motion to adopt the form of the order as is before us with the addition of that one sentence. Movant?
I don't see any problem with that, Mr. Chair.
Mr. Wong?
No problem, Chair.
Okay, we have a modified motion before us for your consideration. We are in discussion. Do you want to speak towards your motion, Mr. Axon?
Mr. Chair, I believe everything that I have to say is on record.
Commissioner Wong?
Yes, Chair. I just want to say that this project and motion was, everyone had a say, even the interveners and the community. It was a very difficult, but the petitioners did a very good job in bringing in all sides and even bending over backwards to get changes to the Ko'olaupoko and other people of the Hawaiian community on board. And I want to just thank them and also everyone who drafted this finding of fact for all their due diligence and their work on this. That's all, Chair.
Thank you, Commissioner Wong. Commissioner Chang.
Thank you, Mr. Chair. I, like Commissioner Wong, have greatly appreciated one, the drafter, staff, and all those involved in preparing this very detailed findings and fact conclusion law and order. I think it is very comprehensive. This is decades of work that have been involved in this matter, but there's been a lot of sensitivity and care taken in the drafting of the order to accurately reflect, I think, the discussion, how difficult it was, and more importantly, the conditions that the petitioner has agreed to abide by. These are their representations that they will be held to. And I think that it's very clear that there are many people that are interested and they will be monitoring this. I just did have one concern with Commissioners Okuda. I totally agree that I think it is Ko'olapoko Hawaiian Civic Club that will be involved, but I am a little cautious about presuming that. I think that there is an understanding and they have been involved in this with the petitioner for many years, but I don't want to bind them in the event that they have second thoughts. But I think I would just prefer that it be kept more open, that it is, they can consult with the Ko'olapoko Hawaiian Civic Club, but again, I'm not sure that the Culture Preserve is going to be actually executed with them. So that's my only reluctance in Commissioner Okuda's
Amendment to the motion.
yes, thank you.
So procedurally, Commissioner Cabral, I recognize that you had your hand up before, but I'd like to give a chance to Commissioner Okuda to respond. I will also note that having read the entirety and edited the entirety of the 160 pages, that in a number of places, references to the Ko'olapoko Hawaiian Civic Club includes or other Hawaiian organization. Mr. Okuda.
I would request that the sentence remain as is. And the reason for that is that there were specific representations specifically identifying the Ko'olapoko Hawaiian Civic Club. And that, I believe, was a major factor in gaining support for this project. I facetiously kind of indicated we wouldn't want the Gary Okuda Civic Club involved. So I think it's specific, since the Ko'olapoko Hawaiian Civic Club was specifically mentioned repeatedly. There was a memorandum of understanding submitted as part of the evidentiary record that they should be named. If it turns out that for whatever reason, an agreement cannot be executed with the Ko'olapoko Hawaiian Civic Club, then the appropriate motion can be brought regarding that. And so that's my comment to that. I would just like to add one thing. My vote and this discussion is in no way intended to denigrate or take away the fine legal work or the reputation of Mr. Matsubara and Mr. Tabata. I truly believe they are some of the best dedicated attorneys in Hawaii. They truly have the state's interests at heart. And I know that from my years in practice. So my vote is no reflection on what they've presented. But that's my explanation, Chair.
Did you have a follow-up, Commissioner Chang?
Well, I would just like to proceed. I would hate for them to have to come back with the motion, but that is the motion that's on the table. So let's hope that they will follow through. The Ko'olapoko Hawaiian Civic Club will indeed be the entity, but I just feel very uncomfortable binding them. But the bottom line, I just would like to proceed with the motion. So unless Commissioner Axon and Wong want to change their friendly amendment to include the broader Ko'olapoko Hawaiian Civic Club and or another relevant Hawaiian organization, as the chair had indicated. That's my only comment, Mr.
Thank you
Chair.
for your comment, and you're correct. We do have a motion before us. Commissioner Cabral. Thank you for your patience.
Yes, thank you. No, I wanted to echo everyone's sentiments, including Commissioner Chang's and Okuda's. As I spoke yesterday on a completely separate matter because it was subdivisions that are managed into the future, I too agree with Commissioner Chang. I hate tying it to someone because at 40 years from now, the whole world could be different and that organization may not exist. And you hate to have everybody constantly coming back to a future land use commission for every time something changes. So I'm hesitant. I'm going to support the motion because the greater good is represented there. And I appreciate the work of all of our fellow commissioners for putting that together. I also wanted to express, this has been a really long hearing. In fact, I thought it'd been a couple of years we've been hearing it, but it's just been a long year here. So, but is that both the attorneys involved and the interveners, and they're, I guess, not present now, but I wanted to express my appreciation for the amazingly good job that they did of providing relevant concerns and information to counterbalance. And it was clearly not an easy decision. But then again, I guess we don't get paid for these easy decisions. So thank you to everyone for their hard work on this matter. Thank you.
Thank you, Commissioner Cabral. Commissioners, is there further discussion on the matter before us? Commissioner Axon.
Mr. Chair, I want to also echo Commissioner Chang concern on this one. And if Commissioner Chang has some additional amendment to open up to, in addition to co-law, I'll be happy to entertain it.
Commissioner Chang.
Thank you, Commissioner Axon. My only amendment would be to be consistent as Chair Schreier has indicated throughout the document. It's while there is reference to Ko'olau-Poko Hawaiian Civic Club, and please do not misunderstand me. I believe that Ko'olau-Poko Hawaiian Civic Club has made the difference in this project. That partnership, that cultural sensitivity, their participation with the petitioner, in my view, has made all the difference. However, I would prefer that we be consistent with the entire document, and I do not want to necessarily bind Ko'olau-Poko Hawaiian Civic Club. If they choose for whatever reason not to be involved as the recipient of the preserve, but rather just a consulting party, then that should be their decision. So I would make an amendment that that it be read that Ko'olau-Poko Hawaiian Civic Club, or I think, and maybe
if I might offer,
yes.
Commissioner Chang, for instance, on the finding of fact contained on page 107,
okay.
The sentence begins with allowing the Ko'olau-Poko Hawaiian Civic Club or other local Native Hawaiian organization, to manage and steward the cultural preserve, supports Hawaiian cultural practices, and so on. So, or other local Native Hawaiian organization.
Yeah, I would be comfortable with that, or even in deference to Commissioner Okuda, that the Ko'olau-Poko Hawaiian Civic Club be given preference, and if not, any other, as Chair, you indicated the language.
A request to further amend the motion has been made. Commissioner Axon.
Mr. Chair, before I accept that, I just want to ask Commissioner Okuda, will that satisfy your amendment in addition to your amendment?
With all respect to everyone, I'm sorry, but it wouldn't, because as stated, I believe that the specific identification of the Ko'olau-Poko Hawaiian Civic Club makes all the difference. And by the way, the reason why I asked, well, no, that's all I have to say. So I'm sorry, it still wouldn't.
Okay.
I believe Commissioner Chang's amendment specifically mentioned the co-allow, so I will accept that amendment.
Commissioner Wong?
No problem.
Okay, our further amended motion before us is to adopt the form of the order, but with the additional line offered by Commissioner Okuda with the additional phrase offered by Commissioner Chang. We are in discussion. Is there anything further, commissioners, on this matter? I'll just say to this particular last minor point in our very long and complex multi-year process of first approving the EIS and then approving the project, that I do believe that there's actually enough in the record specifying the Ko'olau Poko Hawaiian Civic Club as the potential steward, that even with this amendment, that if somehow I have 100% expectation that the agreement will be with the Ko'olau Poko Hawaiian Civic Club. If it doesn't come to pass, I would actually expect that there's enough in the record, presuming that they were to be the entity, that at the very least, the petitioner would come to us with a briefing, if not a full motion to amend, even without this language. If there's nothing further, we have a motion before us, as stated, made by Commissioner Axon, seconded by Commissioner Wong, amended by Commissioners Okuda and Chang, with the amendments accepted. Mr. Ordenko, would you please poll the commission?
Thank you, Mr. Chair. The motion is to approve and adopt the final form of the order with amendments proposed by Commissioner Okuda and Commissioner Chang to page 153 of the proposed decision and order. Commissioner Axon.
Yes.
Commissioner Wong.
Aye.
Commissioner Okuda.
No.
Commissioner Chang.
Aye.
Commissioner Cabral.
Yes.
Commissioner Giovanni.
Aye.
Commissioner Ohigashi is absent. Chair Scheuer.
Aye.
Thank you, Mr. Chair. The motion passes with 6 yes votes and 1 no.
Thank you to the parties in this matter, Mr. Tabata, Mr. Matsubara, City and County, Office of Planning, and interveners.
Thank you.
Okay, we've been going 40 minutes. It somehow seems longer, but 38 minutes. Our next order of business. Let's go for at least another 10 minutes. Well, hold on. Mr. Giovanni, you need to leave at 10, correct?
10 sharp, I have another commitment.
And Commissioner Ohigashi comes at 10:30, is that correct? Yeah. Okay, well, let's proceed and see how far we get. Our next order of business is docket number SP, related to docket number SP 97390, a consideration of the LUC staff's request to issue an errata to the LUC order for the 4th amendment to the state special permit SP 97390 for the proposed Central Maui Landfill Facilities Project dated August 13th, 2020 at TMK 23-800300019, a portion thereof, as well as lot 20, Pu'unene, Maui, Hawaii, to correct the number of acres subject to condition 23 and the related findings of fact. Will the parties for dockets number SP 97390 please identify yourselves and turn on your video as well. Starting with Mr. Hopper, followed by Ms. Thompson.
Thank you, Chair. Mr. Hopper is attending another meeting. So on behalf of the Office of Planning, we have Jordan Hurt, Deputy Director.
Okay.
However, my name is Rochelle Thompson. I'm First Deputy Corporation Counsel for the County of Maui, and I'm representing the Department of Environmental Management. And with me, although we're not at the same location, but present at the meeting is Eric Nakagawa. He is the director of the County of Maui's Department of Environmental Management and the applicant, as well as Elaine Baker, project manager. Thank you.
Thank you very much, Ms. Thompson, and all. Office Planning.
Good morning. I don't think that we are a party to this, but we are present and have provided public testimony that we would like to speak to if possible.
Yeah, that's correct. Let me update the record. On August 13th of 2020, the Commission mailed its decision and order on this matter. On September 23rd, the Commission dismissed the Office of Planning's motion for reconsideration, and I directed the staff to add consideration of the LUC staff request for an errata to the LUC order for the fourth amendment of the state special permit to this agenda in order to correct the number of acres subject to condition 23 and related findings of fact. On September 28th, 2020, the Commission mailed our October 7th and 8th, 2020 notice of agenda to the parties and to our statewide Oahu and Maui regular and email mailing lists. Further, the Department of Environmental Management, County of Maui, offered comments on our October 8th, 2020 LUC meeting agenda and agenda item 9 on SP 397-390, a filing dated October 7th. And on October 6th, as stated by counsel for the Office of Planning, the Office of Planning has offered a comment letter on this matter. I believe that's the entirety of the record to the updates to this point, Mr. Hakoda.
Yes, Chair, sir.
Okay. Has there been any written testimony other than those two offered on this matter?
Not to my knowledge, Chair.
Okay. So is there anybody in the audience wishing to provide public testimony on this matter? If so, raise your hand using the raise your hand function. Seeing that there's no public testimony on this matter, LUC staff will be called on to describe the action it would like the Commission to approve regarding errata on special permit 97-390. And then, sorry, excuse me. One moment, I'm gonna call for a short recess and recognizing Commissioner Ohigashi has joined us.
Commissioner Ohigashi, can we do a mic check, please?
Hello.
Sounds good. Thank you, Colonel Sanders. It's supposed to be a bow tie, not a regular tie, Commissioner Ohigashi.
Here's the procedures we're going to do. We're first going to hear from, there being no public testimony other than the written public testimony from the applicant and the Office of Planning. I want to first hear from the staff, their presentation on why they seek this errata. And then I will allow a presentation by both the County of Maui Planning as well as Environmental Management, followed by a brief presentation of their comments from the Office of Planning, with questions being allowed to all of those parties by the Commission. Commissioner Ohigashi.
Is there any thing that occurred during my absence that would require me to review the record prior to voting on this matter?
Not on this docket regarding the Central Maui landfill.
Thank you.
Yeah, thank you, Commissioner. So that's our procedure for this docket. Let's hear from the LUC staff.
Mr. Chair, this request stems from some confusion that occurred and by staff, actually. When staff drafted the decision and order in this matter, it was unclear as to whether or not the requirement that the applicant seek a district boundary amendment was limited to the 22 acres of important agricultural land or the 95.659 acres of the total permitted area of the CML, the Central Maui landfill. After review of the record and discussion among staff, we concluded that in fact the commission intended, when it made its motion, original motion in this matter, and directed staff to prepare a decision and order, that the requirement to seek a district boundary amendment was intended to be applied to the 95.659 acres of the Central Maui landfill. We therefore request permission from the commission to correct that error in paragraph 23 on page 58, striking the language 22 acres of important agricultural land and inserting language 95.659 acres of the total permitted area of the CML, and finding of fact number 12, in which we once again make the same change, as well as finding of fact number 135 on page 43, again making the same change of changing the acreage to 95.659 acres. And finding of fact, as well as making the same change in finding of fact number 138 on page 46. These changes will therefore render the decision and order consistent with the motion that was made by the commission in the original proceeding.
Okay, questions for Mr. Ordenker from the commission? Commissioner Giovanni.
Thank you, Chair. I believe I was the move-on for the order in this particular case. And as Mr. Ordenker explained, it was the intent to for the condition to apply to the full 95.659 acres. So I thank the staff for coming forward to correct the error. It is consistent with the original intent of the move-on.
Commissioners, further questions for Mr. Ordenker? If there's none at this time, I'll make time available for Ms. Thompson and to direct the county's presentation on this matter. We will probably take a break in about 11 minutes.
Thank you, Chair. Rochelle Thompson, again, speaking on behalf of the Department of Environmental Management. So DEM has submitted its written testimony, so I'm going to summarize the points that we wish to make today.
Excuse me, before you continue, will you speak louder, please?
Yes.
This is the court reporter. Thank you.
Thank you. So DEM submits that consideration of the LUC staff errata is procedurally deficient in that it seeks to substantively amend the LUC's adopted decision and order, which granted DEM's petition to amend SP 97-390 by modifying the acreage subject to condition number 23, which presently requires DEM to seek a district boundary amendment for the 22-acre portion of the project area that is designated important ag lands. So as noted, this is a substantive change to the DNO, which should not be addressed by the LUC by errata, which should be reserved for minor typographical or clerical errors. Additionally, the DNO was provided in advance to the commissioners prior to the LUC's adoption of the DNO on the 45th day, which is the deadline for the decision being August 13th, 2020. If the commissioners did not at that time agree that the DNO accurately reflected their decision made following the close of the hearing on July 9th, the opportunity to address that would have been on or before the Commission's August 13th adoption of the DNO. So both the Office of Planning and DEM requested to obtain a proposed DNO in advance of its adoption, but were not provided that opportunity. Arguably, LUC Rule 15.1582B requires service of the proposed DNO on the parties. Although I recognize that and have been told that that's not the practice for these types of applications and the DNOs involving special permits. DEM further submits that it was procedurally improper to deny the Office of Planning's motion to reconsider filed on August 31st, where its oral motion to amend, which was made during the hearing on September 24th, 2020. Although both DEM and the County Department of Planning filed joinders to OP's motion, neither was allowed to provide the opportunity to offer arguments on September 24th. So at this juncture, DEM suggests that the LUC may rescind its decision to deny the Office of Planning's motion for reconsideration or a motion to amend the condition, or it might rescind its decision to adopt the DNO. DM further requests the opportunity to offer its arguments on these, the motion to either reconsider or amend, so that the LUC can develop a full and complete record on the acreage subject to the DBA requirement. We wanted to add that in a review of the transcript of the July 9th hearing, it appeared that the commission was leaning more toward requiring the 40-acre portion of the project area that would be considered for the buildings and other like Butler buildings and structures, for the recycling activities. There was a lot of discussion about those being more industrial type uses rather than traditional landfill, the actual hole in the ground landfill, and that those types of uses the commission seemed to indicate were more of a permanent nature, and there therefore should be subject to the district boundary amendment. Requiring a DBA for the entire 96 plus acre project area is an immense expansion of the requirement. Not only will it affect the Central Maui landfill, but it will also affect the 3 other active landfills within Maui County. It's not a small requirement. These involve, multiple year and upwards of probably $500 to $1 million per site. So the ramifications of this condition are quite immense, and we respectfully request that the LUC give this the weight that it deserves and the opportunity for further argument. Thank you.
Is there anything further from the other Maui parties, Ms. Thompson?
I'll check in perhaps with Jordan Hart, Deputy Planning Director, to see if he has anything further to add.
Chair, thank you. Yeah, I would like to add, I'm not going to make
Jordan,
any...
sorry. Do you swear or affirm the testimony you're about to give us the truth?
I do.
Thank you.
Thank you. So, without Mike Hopper here, I'm not going to address any of the procedural issues. But just from a land use planning perspective, the planning department needs the tool of the special permit to address issues like this. There's a flexibility issue that occurs sometimes when the foreseeable life of a landfill changes unexpectedly, as has happened a number of times on Maui for various reasons. And I'm sure that there will be other situations in the future that we can't foresee that'll cause that to happen again. And so I think that having that tool in the toolbox for land use planning is important for us. To reiterate what Ms. Thompson mentioned, we do have 3 other facilities in the county, and we wonder, what makes this decision different from any potential requests when those ones come forward, or is this expected to be applied to all. From my perspective, it wasn't really clear specifically why this happened at this location now. There was consultation with LUC staff by the petitioner earlier on in the process, and there wasn't really a substantive indication that this might be something that's forthcoming. And I don't really think that the discussion that I heard, clearly explained for me why this is different. And then, the final thing is that we really just strongly do feel we need this option and do need to figure out a way to pursue how it'll be addressed in the future. Regardless, anyway, based on the outcome of this discussion. Thank you.
Mr. Hart. Commissioners, are there questions for Ms. Thompson or Mr. Hart? Ms. Thompson, you're suggesting, if I understood your written testimony and your oral summary right now correctly, you're suggesting that we erred by dismissing OP's motion for the reason that it was filed in an untimely manner?
Yes, and specifically that motions to amend. So the oral motion to amend, so the motion to reconsider is one thing. And I think the Office of Planning has provided that there would have been no opportunity to file a timely motion for reconsideration because the LUC made its decision on the 45th day. So that was under Section C of, pull up the rules here, that there was no timely opportunity to file a motion for reconsideration. Therefore, they made the oral motion to amend the permit condition, which was not granted, and we believe that was an error. And it would also further, allow the commission to make a full and complete record, because if it is going to require a DBA for the entire 96 acre permit acreage, that's an enormous change, and we believe that the record doesn't currently support that.
My question, just to be clear, was specifically focused on our discussion on choosing to end the proceedings was focused on a very particular administrative rule that specified when a motion could be timely filed. Are you suggesting that the Land Use Commission misread that rule?
I believe that they believe that the motion to amend, the oral motion to amend, although it was made after the close of the hearing, was properly made pursuant to.
So let me try one more time,
okay.
And then I'll stop harassing you. A written motion for reconsideration was filed, and we determined under our rules that it was not filed in a timely manner based on an administrative rule of ours. Are you suggesting that we have misread that rule? That is my narrow question.
Yes, I do believe so. And the reason that I believe that it was a misreading of the rule is that it would render that section of your rules absurd if there were no opportunity to file a motion for reconsideration because the clock had run.
You feel that if the Office of Planning had filed within 45 days, or within 7 days of the 45-day end, that would not have been timely either. Like the 45-day clock ran, we filed our thing, and if they filed within 7 days of the written motion, or the written order being issued, that also would not have been timely and therefore absurd? Because they didn't. It was well after that.
I understand that. I honestly, I think that rule is, it's not all that clearly drafted, but I do believe that that there's a provision for reconsideration, and that it was denied based on the 7 days. But Section C of that rule discusses within the time frame, but not after the time frame required by the LUC to make its decision, which is the 45-day.
It's 10 o'clock. We have just lost Commissioner Giovanni as indicated. It is time for a 10-minute recess. We will reconvene if there's any further questions at 10:10 if there's any further questions for County of Maui, and then we will hear from the Office of Planning. 10-minute recess. We're back on the record. Thank you for the 10-minute break. We are offering the commissioners opportunity to ask questions of Ms. Thompson or Mr. Hart. Commissioner Chang.
Yes, thank you, Mr. Chair. Good morning, Ms. Thompson. As I understand the staff, LUC staff's errata, it's actually to correct essentially a typographical error. That the commission's intent, as confirmed by Commissioner Giovanni, who made the motion, was to require the DBA for the entire parcel, the 90+ acres, not just the 23 acres. And so we're not doing anything substantively. We are just correcting essentially what I would consider a typo, which an errata to me is appropriate to do that. Because what it appears is that the county is asking us essentially to reopen the hearing. There was opportunity during the hearing for the county to address the Land Use Commission's concerns about use of a special use permit for landfills. And this was not the first instance where issues like this have been raised. The Waimanalo Gulch issue, that's come before us. The commission has also raised the question about whether a special use permit is appropriate. So I guess my question to you is that that the counties, your letter is essential in my view, asking us to reopen. Is that what you're asking us to do?
Thank you, Commissioner Chang. Yes, on the narrow point raised by the Office of Planning in its motion for reconsideration or oral motion to amend following the hearing is to just develop for the commission so you can make a full and complete decision on the record as to which area, if any, should be the subject of a district boundary amendment. When I reviewed the transcript of the hearing, there was no clear indication, at least in my reading of it, whether it involved just the important ag lands section, the 22 acres, the 40-acre project site, which I think many commissioners noted certain concerns about the type of proposed uses on that area. And I know that the county made the arguments at that hearing and in its application that these uses were all ancillary to the actual landfill, the hole in the ground landfill uses. So, or whether it involves the entire 96 acre project, special permit project area. And the reason that that's important is not only for this permit, but in going forward, as the Department of Planning mentioned, we have 3 active landfills, and that's just within Maui County. And my understanding is that the other counties also use this special permit vehicle to permit their landfills. So the decision potentially has very broad impacts, for land use and land use planning. And so if the commission is going to go this way, we would appreciate the opportunity to develop a full record so that, it's clear not only to Maui County, but to the other counties, which direction everybody is instructed to go in going further forward.
Thank you for that explanation. Is there anything that precludes the County of Maui from raising this at another time before the 5 years to come to the LUC and raise those questions in a more appropriate motion? My problem is that this came to us under a motion for reconsideration. there's a very, in my view, a very narrow legal basis upon which we reconsider. That there was a full opportunity for discussion at the hearing where the public was invited to participate in that. They heard the testimony. So legally, I find that this is an appropriate vehicle to be raising what I consider a substantive issue versus a typographical error. But let me ask again, is there anything that precludes the County of Maui from coming to the Land Use Commission at another time before the 5 years to ask that this particular condition be removed and you develop a full record about why it should not be a DBA isn't required? Because you're putting the burden on the LUC. So is there anything that precludes you from coming back?
Thank you, Commissioner Chang. We could file a motion to modify the condition and then go through the normal route through 1550-96.1 to go through the Planning Commission and then back to you, the Land Use Commission. So yes, we could go that route. I think our point today would be if that is the recommendation, or if that's what happens here, is to leave the decision in order as it was adopted by the LUC with the 22 acres. And then we would, move forward from that and potentially seek to modify that condition going forward. But in that case, our request would be to leave the decision in order as it has been adopted.
All right, thank you very much. I have no further questions.
Thank you, Commissioner Chang. Commissioners, further questions for the county? Commissioner Ohigashi.
I have a question for Mr. Hart. How many of these other landfills in the county of Maui are planning to have a industrial type use area next to them by the county?
Thank you very much, Chair. I'll try to respond to that. The first thing I'll say is that let me address the use issue. It may be considered to be industrial in nature, but it's accessory to the county's facility. And so, there's a discussion that was happening previously about industrial parks and things like that. And I think that there's a significant difference for the county between commercial industrial operations and utility.
Yeah, I'm sorry, Mr. Hart, if I may, and you're going to now be the recipient of yesterday's proceedings with people taking very long and diversionary explanations in response to specific questions. I'd like you to answer Commissioner Ohigashi's specific question, which was how many other landfills in the county on the island have this kind of, if you want to call it accessory use, or his words were industrial uses.
Sure. So I think that the appropriate person to direct that question to would be environmental management.
Who specifically, Ms. Baker?
I'm not certain of the I think Ms. Thompson can identify the representative that she has with her today.
I believe Eric Nakagawa, the Director of Environmental Management, is, yes, there he is.
There you are, Mr. Nakagawa. Aloha.
Aloha.
Do you swear or affirm the testimony you're about to give is the truth?
Yes.
Okay. Mr. Ohigashi, did you hear his question?
Yes.
Please respond.
I think potentially all of them. I think do you want me to elaborate or just keep it yes?
Commissioner Ohigashi?
No, I just wanted to know how many have, any of them have these industrial park uses now? Industrial accessory uses now?
Sorry, I just have a hard time. I can say yes or no, but I don't know if it'll make sense. I'll just say no.
He'll say no.
Well, do you want me to?
Go ahead and expand.
Oh, okay, sorry. I didn't want to get scoldings also. So, I think Giovanni, I believe during the discussions explained it well in that the look in the landscape of a landfill in the future and now is totally different than what it was 30 years ago. 30 years ago, it was a hole in the ground. You filled up with every piece of rubbish, whether that's plastics or this, whatever. And that's different now. And it's not because we want to do it as far as an department, but it's what the community wants and what everybody thinks. You got to recycle. It's a landfill diversion. So that's why we say it's ancillary or accessory, I guess. So in the future, absolutely. I think in the future, all of them will look different. Whether they have a Butler type style building where they're separating out the different type of recyclable materials. And there's just regulatory requirements that do not allow us to landfill certain things. And that's why when you ask me, are they now? I'll say, no, there is recycling, but I believe this body that I can remember when they were talking about it is the heartache was a Butler building with a concrete slab and all that kind of stuff. Those are just regulatory requirements that we need to comply with. And therefore, when we do those type of activities, we need to build that. You can't just do it on the ground. If we could do it right on the ground, we would have done it in a agricultural type setting. So, I mean, so that's why I say no, because there is no Butler buildings currently there. But in the future, absolutely yes, because you cannot landfill certain items now per regulatory requirements. So everything is changing as far as the landscape of what a landfill will look like in the future.
I understand Commissioner Giovanni's line of questioning or his expression of thought. He indicated that the type of recycling and the type of activities, you know, I think was confirmed by your department, could occur on a separate lot or separate area, similar to what H-Power is being used for in Oahu. So I understand your concern, and when it would appear that the choice is up to the county as to how it wants to proceed forward. I'm just saying that I'm supporting Mr. Dan Giovanni's position with regard to his intent, what was stated, his correction or his belief on what the errata should contain. And I join Commissioner Chang in her feelings that if this is going to be modified, that the burden is upon the county to show why it should be modified and to establish and to file the necessary motions to do so. That has been my concern all along. It took the department, looks like the Department of Planning took the lead in determining this issue. And for all I could see at the hearing and even after during the discussions, it would appear that the County of Maui has taken more of a neutral position on this matter. So if you feel very strongly, I think that the proper exercise be that the County of Maui take the initiative and put together your case, provide us through the Planning Commission the information necessary to determine whether this condition should be moved. That's all I have.
Okay, Commissioner Ohigashi, I'm understanding your recent statement to be more of a comment than a question directed at any of the three individuals. Okay, thank you. Commissioners, questions for Maui County? If not, Office of Planning,
Thank you,
Ms.
Chair.
Takeuchi Apuna.
Thank you, Chair. We appreciate the opportunity to provide these comments. OP believes, like the County of Maui, that there were procedural errors with the dismissal of OP's motion for reconsideration and this agenda item that asked the Commission to correct the required DBA acreage in Condition 23 of the Central Maui Landfill SP decision and order. First, OP acknowledges that it was late in its motion for reconsideration filing, but the Commission's filing of the DNO on the 45th day within which it could act on the special permit would deny any person or party the opportunity to file a motion for reconsideration. Moving forward, we hope that decision and orders for special permits, DBAs, and deck rulings are timely filed by the Commission. I actually received a call from County of Maui Deputy Corporation Counsel asking when the deck ruling would be filed on the short-term vacation rental issue that we had. That petition was filed, I believe, May 19th, and the Commission was supposed to act within 90 days of that. We are far past 90 days and there's no declaratory ruling filed in that matter. So I think that the Commission is beyond the 90 days within which to act. Secondly, we understand and appreciate the Commission proceeding cautiously when it comes to providing public notice. But under the rules, OP's verbal motion to amend did not require public notice and would not have denied the public a proper notice because the substantive arguments and relief requested of both motions were basically the same. Lastly, and most importantly, the Commission should not issue an errata on the specific DBA acreage. There are substantive considerations that have begun based on certain comments made by commissioners at the last hearing and even today. And that should also include the arguments yet to be made by the County Department of Environmental Management and Department of Planning. OP therefore respectfully requests that the Commission deny the LUC staff's request for an erratum to the specific acreage of the Central Maui Landfill Special Permit Condition number 23. One last point, I think the Commission went through extensive arguments on a DBA for the Waimanalo Gulch landfill, and that has been brought up previously, but ultimately there was no DBA condition placed on the City and County of Honolulu. But that was a completely separate record through which the County of Maui did not participate in and would have no reason to be aware of those arguments or those comments made by commissioners as far as a special permit. They should have full opportunity to make their arguments separate from those that were made at the Waimanalo Gulch landfill. Thank you.
Thank you, Ms. Apuna. Commissioners, other questions? Commissioner Wong.
Thank you, Chair. Good morning, Ms. Apuna.
Good morning, Chair.
I have some concerns with your statement you just stated. As you know, you were a party of the Maui landfill from day one, pretty much, and you knew where we were going. And I'm very concerned the statement that you said about the staff and the Land Use Commission about their timeliness issue. I'm very concerned that to do a DNO in one day would be ridiculous for any of us. As you saw in our last dockets, we took some time to go even to do that finding of facts, conclusion law, and decision order. And just to say that we can turn it around in like a couple weeks is ridiculous to me. So it's just a statement of fact. Other thing is about the Waimanalo Gulch. I think we did put it in their DNO, but we did tell them if they do want to come back, they should do a DBA. I think I said it to them, so it's not maybe not in their DNO, but we did state for the in the minutes. And I think that all DES or departments statewide do talk about things and they know about things happening, because they'll say, hey, did you hear what the Land Use Commission did to us this time? I mean, people do talk on the island. So I I take some offense to that. So I just wanted to say for the record that those things I'm a little concerned about those statements that you say that the Land Use Commission should have turned around something so shortly when our staff worked their darndest to try and do things in a timely manner. And also in the errata sheet, I believe this is the proper way to do something. And I'm going to support Mr. Giovanni's issue that we should use the errata. That's all. Thank you.
Thank you.
Commissioner Chang.
Commissioner, may I respond to that, Chair?
Go ahead.
Thank you. So thank you, Commissioner Wong. I appreciate your comments. As far as we are not asking that the commission staff provide a DNO within a day or within 2 weeks. We're asking that the staff provide the decision and order within the 45 days minus 7 days within which a party can submit their motion for reconsideration. This is consistent with your rules. So we're not asking for, you know, a quick turnaround. We're just asking that you be consistent with your rules. As far as Waimanalo Gulch, I understand that there were arguments made there on that special permit and the possibility of requiring it, but that never happened. But my main point there is that the Maui County was not part of that whole proceeding. And maybe there are discussions, but I don't believe that Maui County or even Office of Planning was aware or thought that it would become an actual condition. The only time it was raised as a condition was during deliberations by the commissioners. And I think I speak for Maui County and OP in saying that we were caught off guard. We were really surprised that it became an actual condition. We understand that we think that the commission believes that the counties should look in that direction and consider doing a DBA rather than an SP, but it was kind of a last minute condition that was imposed, and we were pretty much shocked. And I think that's why the county and OP are here again to strongly say that we don't believe an SP is an appropriate vehicle. And yeah, so thank you for your comments.
Chair?
Commissioner Wong, followed by Commissioner Chang.
So thank you, Ms. Apuna. I guess I always protect our own, the Land Use Commission staff. So that's just a statement. The other thing is, I think the commission, as it sits now, we don't believe a special use permit should be done, you know, that would be forever. For example, let's say a school, which I think it should be a DBA. No, it shouldn't be a special use permit. So I think this commission, if I may speak on behalf of the commission on this, that special use permit is special and should be short term. And DBAs, you know, do the DBA if needed. So I think that's what we're trying to state. And that's all. Thank you.
Thank you, Commissioner Wong. Commissioner Chang, followed by Commissioner Okuda.
Thank you, Mr. Chair. Thank you, Ms. Apuna. I wanted to ask you, your comment about the rules, 15-15-84 specifically provides a motion for reconsideration shall be filed with the commission within 7 calendar days after issuance of the commission's written decision and order. So it's not from the oral decision. So notwithstanding that it has taken maybe a little longer, it is from the written order. So, and again, I don't want to debate the, you know, what we had talked about the last time about a motion for reconsideration. But in my view, the motion for reconsideration that you filed, it raised substantive issues about the DBA. So that I felt was inappropriate. So let me ask you this question. Is there anything to preclude the County of Maui before the 5 years to come before the LUC after going before the Planning Commission on a motion to amend the condition and permit the County of Maui to provide a fuller record before the LUC on why a DBA is inappropriate.
Thank you, Commissioner Chang. No, I don't think there is anything precluding the County of Maui to come forward and do a motion for modification to the special permit.
Okay. And let me ask you this question on an errata. If it is for a typographical correction, do you believe an errata is appropriate?
If it is a typographical error, yes.
Okay. And in this particular case, based upon the transcript, and now we have an affirmation from the move-on, Commissioner Giovanni, his intention, and from the record, it was to require the DBA for the entire 93 acres, not the 23. So in that case, I see this as a typographical error, not one that there would be a substantive change. Do you agree or disagree?
I disagree in that when you look at the transcript, which we poured over, it wasn't clear. I mean, yes, so Commissioner Giovanni never stated that it would be the full acreage, the 95, but then there was also arguments made by Commissioner Ohigashi referring to the 40 acres of industrial. So it could have been 40 acres as well. And then there's the 22 acres. So I think that I understand Commissioner Giovanni intended it to be 95, but I'm not so sure that all the commissioners understood that it was 95, because just based on a plain reading of the transcripts, there were different arguments that would allow for either 22, 40, or 95 acres.
Okay. And I guess that's the purpose of today's motion, is to accept the staff's errata. And then we'll find out whether all the commissioners agree or disagree with Mr. Giovanni. But Ms. Apuna, would you agree that the commission has a discretion to whether to grant or deny a reconsideration?
Of course, yes.
All right. So thank you, Mr. Chair. I have no further questions.
Thank you, Commissioner Chang. Commissioner Okuda, followed by Commissioner Ohigashi.
Thank you, Mr. Chair. Thank you, Ms. Apuna. Let me first just state that if you, in your capacity as a Deputy Attorney General, believe that any of us at the Land Use Commission, staff, commissioners, or otherwise are doing something which is not in compliance with the rules of the statute, please, speak up. We don't hold it against anyone. That's your duty as a litigator and as an attorney representing the state. But if I can go back, actually, Commissioner Chang had raised this question under section 15-15-84 about the fact that the deadline to file a motion for reconsideration runs from the entry of the written order, not the oral order. Do you agree with that? With the fact that that's what Rule 15-15-84 states?
Yes, I believe from the filing of the written decision and order.
Okay. What evidence in the record indicates that anyone either on the Land Use Commission staff or members of the commission itself prevented anyone from filing a motion for reconsideration within the time frame that is stated within 15-15-84?
You're asking me so based on the facts, I'm just saying that I think that we're saying that because the written order was filed on the 45th day within which the commission could act on the special permit, that the commission is supposed to act within 45 days, that therefore there was no time. They had used up all the time within which to act, leaving no 7 days within which any party could have filed a motion for reconsideration.
Yeah, but 15-15-84 states, and I quote, small parent, small a, close parent, a motion for reconsideration shall be filed with the commission within 7 calendar days after issuance of the commission's written decision and order. So in other words, so my question is, what evidence is there in the record that the Land Use Commission either itself or staff prevented the filing of a motion for reconsideration within 7 calendar days after issuance of the commission's written decision and order?
I don't think there was, well, someone could have filed within 7 days of the written decision order that was filed on August 13th. Yes, there was nothing preventing, the staff would have accepted that. They even accepted ours that was later than 7 days. But according to subsection C, the commission can't do anything after 45 days, the time within which it must act on the special permit. So if they filed it on the 45th day, there's no time for a motion for reconsideration. So the special permit, I can't recall the exact. The commission must act within 45 days from receipt of the full record for the special permit. That was June 19th, I believe. So 45 days from June 19th, the commission needed to act, including act on any motion for reconsideration. But they filed it on the 45th day. So even if I was timely, OP was timely, it was beyond the 45 days within which the commission could act.
Is there anything in the law which requires an agency to allow a motion for reconsideration? I understand your argument here and how the rules might, in effect, under certain circumstances, prevent a motion for reconsideration. But is there anything in the law that requires an administrative agency in Hawaii to allow reconsideration?
I'm not sure if Chapter 91 does, but I can't say right now.
Because in fact, reconsideration, whether it's in court or whether before an administrative agency, doesn't it require new evidence, meaning not only something that is newly discovered, but the standard requires that it's something that with due diligence couldn't have been discovered or presented in the initial presentation?
I don't disagree that might be the case in court, but under this 1515-84 rule, there's nothing that requires that there be any new or different information in order to file for a motion for reconsideration.
So it's the Office of Planning's position that even if an issue had been discussed, maybe adjudicated or discussed and considered over many days, parties to the proceeding basically can just have a blank slate and have a second bite at the apple?
I mean, it's within your discretion, Commissioner, and within the Commission's discretion, I suppose. But I think here, again, we saw that there could be various interpretations of the acreage, and I don't think it's a second bite at the apple as far as that a DBA is not an appropriate vehicle over a special permit. I think it's the county and Office of Planning believing very strongly that we didn't get to provide all the necessary arguments to show that a special permit is the appropriate vehicle.
Yeah, okay, I understand your argument. Thank you very much. Thank you, Mr. Chair.
Thank you.
Thank you, Commissioner Okuda. Commissioner Ohigashi.
My comment is mostly, well, let me put it this way. I'm not sure whether or not it's worthwhile discussing a motion to reconsideration when we have none before us today. If there was a procedural problem, it would behoove the parties to have filed some type of motion so we have it noticed for public hearing, so we meet all of the standards for us to address these issues. We've made our decision. I am sure that Attorney General's office is really smart and they can figure out a way whether or not to appeal our decision on it or to bring it up again to us. However, today, I don't think that we have before us an issue of reconsideration. The real question in my mind is whether or not to move forward with the errata. And if I understand your argument regarding that, Ms. Opuna, is that you believe that there is insufficient evidence to make that leap for Mr. Giovanni's interpretation for us to make that leap. Is that right?
Yes. Yes.
One of the examples that you use is me. But I'm kind of confused since I voted against the motion. However, if you want to know, it is my recollection and my feeling and that the intent was the entire parcel, Mr. Giovanni. I just wanted to clear up that, because if I'm the cause of your confusion, I apologize.
No need to apologize, Commissioner. But yes, no, I think that's helpful. I think that it says 22 acres of IAL. That seems, I mean, you can call it a typo, but if you're talking about specifically IL as opposed to 95 acres non-IL or 40 acres, I mean, it's more than a typo. It's not just a difference in number. But I appreciate that, Commissioner Higashi. I think knowing what the commissioners understood that acreage to be would be helpful.
Commissioners, are there further questions for the Office of Planning?
Chair.
Commissioner Wong.
Mr. Puna, question. So, you know, I know you filed you did file something. Is there anything that stops you from filing a motion to amend?
No, but I think we talked about that. We are the, maybe the county can file a motion for modification of the special permit.
But you filed, the OP filed the motion to reconsider. So, I mean, I'm sorry, I'm confused. You know, you did something already. Why can't you stop you from filing something else?
I don't believe we're stopped from doing anything further. We can move forward with a motion to modify, but I think it was important that Office of Planning filed the motion for reconsideration because it was not clear what the acreage was, and we do have a strong position that there should not be a DBA for a landfill, that it should remain as a special permit.
Okay, that's it. Thank you, Mr. Puna. Thank you, Commissioner Chair.
Thank you, Commissioner Wong. Commissioners, is there anything further for the Office of Planning? I guess these might be questions or they might be comments for the Office of Planning. My recollection, first of all, is distinctly different from yours, Mr. Puna. Without the transcript in front of me, I think that we had an extensive discussion prior to deliberation over whether or not a special permit or DBA was appropriate. That's my recollection. And I guess I'll just echo Commissioner Wong's statement. While it has been a now common practice, but not universal, to locate, to put in landfills through the special permit process, I will note that the current construction demolition landfill on Oahu was actually put into the urban district prior to the landfill siting. Well, it's a common practice. I think it's wrong. I think it's contrary to the law. And I, along with Commissioner Giovanni, it was absolutely my understanding at the time the motion was made that it was for the entire 95 acres rather than for the smaller part of the IAL provision. I guess I'm also just going to note for the record right at this time that like part of the dilemma that we're in was that it took so long for the county to come to us with this thing in the first place. And we were forced into a tough position of potentially denying them a special permit and illegally operating landfill because of the late hour. So yeah, maybe we filed something on the 45th day, but we were not the first person to come close with deadlines. So I kind of a little bit share Commissioner Wong's feeling a little bit irritated at the suggestion that somehow the Land Use Commission is the source of all the problems in this matter. Anything further, commissioners? Questions for any of the parties, including, or the people we've been discussing things with, including the staff? If not, commissioners, what's your pleasure on this matter?
Chair, Commissioner Wong here.
Commissioner Wong.
Okay, so just wanted to just get a point of clarification first before I do anything.
Okay.
It's the errata itself, right? Where we're deliberating on. Is that correct first?
Correct. The agenda item before us is an LUC staff request to issue an errata to the LUC order for the Fourth Amendment to the State Special Permit SP 97390 for the proposed Central Maui landfill facilities dated August 13th, 2020, in order to correct the number of acres subject to condition 23, as well as the related findings of fact.
Okay, so Chair, I know that Mr. Oradenker stated that that issue of the errata plus changing the findings of facts on this. So can I use that statement as my motion plus add one more portion? Or do you want me to do the entire?
Yes.
Okay, so I'm going to use that portion with the changes of the findings. Plus, I want to say that the chair can sign the order and we don't need to meet again on this.
You're going to delegate authority to the chair to sign an order effectuating this motion?
Yes, Chair.
Okay. Commissioner Ohigashi.
Second.
Okay, a motion has been made and seconded to accept the LUC staff recommendations on changes, the errata, correcting the errata on the decision and order, and to authorize the chair to sign on behalf of the commission. It's been made by Commissioner Wong and seconded by Commissioner Ohigashi. Commissioner Ohigashi, do you have something further to say?
Nothing further. I think I made my statements clear.
Okay. Commissioners, we're in discussion. We have a motion before us. I will also say before I call for the question that I think that it's well established that even if the county feels somehow harmed by this action and that it's improper, they have a number of remedies available to them. The most direct would be to file a motion for amendment of the condition. Commissioner Cabral. Okay.
Thank you. I listened to this, and I'm one of the few non-lawyers in the room here, and I find I appreciate the necessity for all these rules and regulations. Find myself such a practical person. I just want to know, I think we all want to get to the same end here and have it be a successful landfill operation for the county and for the public there. So I just wanted to double check with our executive director and the legal team that helps advise us to make sure that we're all doing the right thing with all of these legal decisions and protocol and procedures, because I am clearly not the expert in all of this. So I just wanted to make sure before we proceed with any kind of vote that our representative from the Attorney General's office and our executive director, Oren Decker, are all on board with this action. Thank you.
I'm going to rephrase your question, Commissioner Cabral, for the point of clarity in the record. Is a two-part question. Does the executive officer stand by his recommendation on errata? And to Mr. Lau, was the motion properly phrased?
Thank you,
That's
Mr.
exactly what I said. Thank you.
If I can address the first question. Yes, we stand by, this is Dan Ardanker, Executive Officer. We stand by our request for correction through the errata process. It was actually done on the advice and with consultation with the Attorney General.
Mr. Lau, has the motion been properly put forward?
Yes, this is Colin Lau, the Deputy AG. I did consult with the prior AG who handled the prior matter, and together we believe that the motion is properly phrased.
Okay.
Thank you very much. I feel much better about having our legal counsel weigh in on this at this moment. Thank you.
Thank you, Commissioner Cabral. Commissioner Okuda.
Thank you very much, Mr. Chair. I'd like to speak in favor of the motion. I agree, even though I believe I voted against the motion, if my recollection is correct, but I do believe Commissioner Giovanni's recollection was my recollection of what the overall intention is. I'd like to assure everyone that, at least for me personally, I'm not prejudging any future application that might be filed by the County of Maui or any other interested person or any other entity or any other county. I do believe that there are certain things regarding the Waimanalo Gulch landfill which may be distinguishable from what has taken place on other islands. I did hear and took to heart the Office of Planning's concern about spot zoning. Again, haven't prejudged anything as far as what might be filed in the future. I will say one thing, however, about Waimanalo Gulch, and I said it at the hearing. I believe that there was something that raises a serious question, and I don't want to call it environmental justice because that's a loaded term. But one of the problems I saw with that landfill is that somehow these landfill and what I've described as negative public facilities somehow always end up in the backyards in Waianae, Maili, and Nanakuli. And that is a concern. It might be just limited to the Waimanalo Gulch landfill. And that concern might be distinguished from what the County of Maui is doing. So I would just like to state that and assure everyone I'm trying to keep an open mind on everything. But for this specific narrow issue about the errata, I believe the errata correctly corrects a mere typographical error. It does not affect substantive rights of the parties. Thank you.
Commission, we are in discussion over the motion, which has been made by Commissioner Wong and seconded by Commissioner Ohigashi. Commissioner Axon.
Thank you, Mr. Chair. I will be voting in support of that motion. Aside from different discussions from OP and also the county, I agree with Commissioner Okura and Commissioner Oigasi that actually my attention is all focused on the narrow issue of errata for the purpose of this hearing. And upon hearing Commissioner Giovanni's statement later, clarifying his motion, I believe we are on the right path on this discussion. So again, this hearing is also regarding the errata that was requested by the staff, and we should be voting directly on this issue. Thank you.
Thank you, Commissioner Axon. Is there further discussion, Commissioners, on the motion before us, which is to accept the errata offered by the LUC staff and authorize the chair to sign the order? Seeing none, Mr. Oradenker, will you please poll the commission?
Thank you. Thank you, Mr. Chair. The motion is to grant staff's request to issue errata to the LUC order for the Fourth Amendment to State Special Permit SP 97-390 and to authorize the chair to sign the order. Commissioner Wong.
Yes.
Commissioner Ohigashi.
Yes.
Commissioner Okuda.
Yes.
Commissioner Axon.
Aye.
Mr. Giovanni is absent. Commissioner Cabral.
Yes.
Commissioner Chang.
Yes.
Chair Schreier.
Aye.
Thank you, Mr. Chair. The motion passes with 7 affirmative votes.
Thank you very much, Commissioners, and thank you to Maui County and all your participants, as well as the Office of Planning, for participating in this discussion and this agenda item. It is now 11:02 a.m. I have been informed by email that Commissioner Giovanni is available starting at noon, so he has been here for the full. He would. Sorry, let me try and be articulate here. Mr. Giovanni is available at noon and could continue his participation in our agenda item regarding HALEKUA Development Corporation. Particularly given his expertise and his background in utility matters, I think the commission would be well served by allowing us to have his participation in this matter. So what I'm going to suggest is that we take an early lunch, breaking now, reconvening at noon, and at which time we will reconvene for the last remaining agenda item, which is the HALEKUA development matter. Is this acceptable to the commission? Since I see some of you are here, Mr. Simon, since you're the only one who's made yourself visible for.
Derek, is that okay?
Yes, that's perfectly well with the petitioner.
Okay, Mr. Lau?
Yes, we're okay with that.
Okay. We are in recess until noon. Okay. It's noon. We are back on the record, and we are now taking up our last item, which was also our second item of this two-day hearing, HALEKUA Development Corporation Oahu, to consider the successor petitioner as to parcel 52 Ho'ohana Solar 1 LLC's motion for modification and time extension, as well as the associated matters raised by HASECO. Let's do appearances, starting with the petitioner.
Good afternoon, Chair, Commissioners. Jennifer Lim, representing petitioner Ho'ohana Solar 1, and with me, as you can see, is Mr. John Pete Minot and Derek Simon, also representing Ho'ohana.
Okay, thank you, Ms. Lim.
Good afternoon, Chair and Commissioners. I'm Stephen Chung, and with me is Michael Lau, representing HASECO Royal Kunia.
Thank you, Mr. Chung. Mr. Takahashi.
Hi, this is Eugene Takahashi, Second Deputy Department of Planning and Permitting, representing the City and County of Honolulu Department of Planning and Permitting. And also be joining me shortly is Molly Stebbins from our Corporation Counsel Office.
Thank you.
Good afternoon, Chair, members of the Commission, Deputy Attorney General Dawn Akuna on behalf of the State Office of Planning.
Okay. So let me first note something that I will later confirm in the record prior to any deliberation, if we get to deliberation on this matter, that Commissioner Ohigashi missed the portion of the proceedings where we had the conclusion of cross-examination of Mr. Overton However, Mr. Ohigashi spent our lunchtime break listening to the recording of that matter, and I will confirm if we go into deliberation that he's prepared to deliberate on this matter. We have also been rejoined by Commissioner Giovanni, who's been here for the entire time. So we have 8 sitting commissioners out of a possible 9, and all 8 have now attended the entirety or been familiar with the entirety of the record in these proceedings. Commissioner Ohigashi?
Mr. Chair, do I have to confirm on the record your representation? If so, I do. And
okay. I will check with all commissioners whether they're prepared to deliberate on these matters prior to any deliberation. Thank you, Commissioner Ohigashi. Okay, so where we are in our proceedings is that we had, Ms. Lim had chosen to pull one witness and present one witness. If the petitioner chooses to do any more witnesses, we will hear from them. Hopefully, if so, very briefly, allowing for cross-examination and questioning by the commissioners and any redirect of any such witnesses. We will then proceed to hear from HALEKUA on their main argument and their witness, City and County of Honolulu and the Office of Planning, followed by any rebuttal from the petitioner, at which point we will conclude argument and go into deliberation. Are our procedures clear for today? Ms. Lim?
Procedures are clear, thank you.
Mr. Chung?
Yes, Chair. Yes, Mr. Chair.
Mr. Takahashi?
Yes, it is. It's clear.
Ms. Apuna?
Sure.
Okay. Ms. Lim, give us an overview of how you're planning to proceed before launching into it.
Okay, I will do so. Thank you very much, Chair. We filed many exhibits, including those exhibits as written direct testimony by not only Mr. Overton, but also Mr. Green, Mr. Wallenstrom. There's other written direct testimony and many other items in the exhibits. We also pretty extensively briefed this matter, both in the motion that we filed in August, as well as 3 reply briefs that we filed in response to HALEKUA's document, which we were never served a copy of, and OP's filing and DPP's filing. So in light of all of that, in light of the fact that the commission has no doubt gone through these extensive filings and that we've already taken up more time than would otherwise be expected in a simple motion like this, petitioner is willing to really rest on the filings that we've made thus far. And of course, we're available for questions that the commission may have, but we don't intend on bringing up our witnesses.
That is happy news, Ms. Lim, and I agree with your characterization of everything, including your extensive briefing and the fact that the commissioners are very diligent in reading all of your extensive briefing and direct testimony. Commissioners, are there any questions for the petitioner at this time? Commissioner Okuda.
Thank you, Mr. Chair. I just want to assure Ms. Lim that I have read all of her filings, and I've also read all of the other filings, and I would like to assure Ms. Lim that I have also studied very carefully the direct testimony that she submitted. So I'd like to assure her that she is, at least for me, she is not waiving any real advantage by submitting on the record. Thank you, Mr. Chair.
Thank you very much, Commissioner Okuda. Commissioner Chang, followed by Commissioner Giovanni.
Thank you, Mr. Chair. And Ms. Lim, I greatly appreciate your facilitation of this hearing. This is, you know, I see this more as a motion rather than as litigation. So thank you again for expediting this and having confidence that the commissioners have read all the materials. So the question that I have is, in your memo in support of your motion, you state that that Ho'ohana is not the landowner. Therefore, they do not have an obligation in particular to condition A.1. Is that your position?
Just confirming, Commissioner Chang, is the barking noise coming from Your location? Okay, so you might
Yeah.
go on mute while the response is going on.
Thank
We
you
are
very much
living in
for-
COVID land. Ms. Lim.
Thank you for the question, Commissioner Chang. And you didn't specify which particular filing you read that statement in, but it doesn't matter because that is a statement that I'm sure we have made in our filings. I know for a fact we have. If you look at the 2015 order, which is the order that we're seeking an amendment to, there's two classes of conditions. And this is, again, in our reply briefs, both that we filed in response to HALEKUA's filing and also to Office of Planning's filings. The 2015 order has two categories of conditions. There are the conditions A, and they go A1 through A4, and then there's conditions B, and that's B1 through B7. And the B conditions state very precisely, and this is on page 54 of the 2015 order, the following conditions B1 through and including B7 shall be applicable only to the solar farm on parcel 52 and shall be applicable only upon the development of the solar farm use on parcel 52. And then it lays out 7 conditions related to requirements that the commission wanted the solar farm developer to fulfill in connection with development of the solar farm. The A conditions that are on page 53 of that order say the following conditions A1 through and including A3 shall replace condition number 19 of the HALEKUA orders. And the HALEKUA orders are defined elsewhere in that document to include the 2 decisions, or there's actually several decisions and orders dealing with the original reclassification. And condition A4 shall replace condition 21 of the HALEKUA orders. And if you look at the conditions A1 through A3, by bifurcating and saying the B conditions apply only to the development of the solar farm, clearly that's a different class of conditions, whereas the A conditions apply to the landowners because the language in condition A1 says within 6 months of the date of the commission's order, the landowners within the petition area shall blah, blah, blah. I mean, I won't read it out unless the commission wants me to read it. I'm sure you have it at your fingertips. Condition A2, within, X number of months, the landowners within the petition area will submit revised master plans. Well,
So,
obviously, yeah, I'm sorry.
The only question I asked is that Ho'ohana, that your representation in your briefings have been that the solar lessee is not obligated under condition A1. They are not the landowner. Just a confirmation. That's consistent
correct.
with your representation. Okay.
That is correct. I'm sorry to be so long-winded.
Okay. So my next question is Ho'ohana's position that the Robinsons, who are the landowners of parcel 52, are bound by those conditions, condition A1?
Well,
because you don't.
I have to be careful here because, as you know, Ho'ohana doesn't represent the Robinsons, so I have a limited ability to make any kind of representation for another party.
You're right.
That's a complete answer, Ms. Lim.
Yeah, and let me ask it this way. I should have asked it this way. Is Ho'ohana's position that the petitioners of the original petition back in 1996, that the Robinsons were a landowner at that time?
The Robinsons were a landowner when the land was originally reclassified.
Okay.
If I could just expand on that very, very quickly, there are 2 declarations of conditions that we filed as exhibits and relating to the 1993 and 1996 commission orders. And in those documents, it clearly says that the Robinsons are not obligated for the conditions imposed by the Land Use Commission. It was the petitioner HALEKUA Development Company. So that's just in the record. I'm not opining on it. I'm just describing what's in the record.
But would you agree that the specific language of the condition only refers to the landowners in the petition area?
The specific language of condition A1?
Yes, I have to, yes, am I reading it wrong? Is that the landowners?
The language from the 2015 order, condition A1, says that the landowners, and the S is in parentheses indicating whether that's one or multiple, within the petition area shall finalize an amendment to an MOU. And as we heard from David Tanoe yesterday, an MOU was in fact finalized and then assigned to HALEKUA. But that is the language in that order.
Okay. And are the Robinsons still the landowners for the property, for parcel 52?
Robinson Kunia Land LLC owns parcel 52. They are the lessor to Ho'ohana.
Have you notified the Robinsons of your filings?
Yes, they've been served with copies of our filings.
And
they also, and they did, of course, provide fee owner authorization for us to file the motion. That's in the record as well.
And has the Robinsons also received copies of all of the pleadings that have been filed in this docket?
I can say with absolute certainty that we served everybody. I cannot say with absolute certainty if the other parties served the Robinsons. I could look right now because I have the pleadings and I can look at the certificate of service, but.
So let me ask you this. Did you serve the Robinsons with your reply briefs to both HALEKUA's motion, OP's motion, and DPP's motion?
Yes, ma'am.
Do you know why they aren't participating in this action? If you know, if you don't know, and if you're speculating, you don't need to answer.
It would be speculation for me to say.
Mr. Chair, at this point in time, that's the only question I have right now.
Thank you, Commissioner. Commissioner Giovanni.
Thank you, Chair. Greetings, Ms. Lim. How are you?
Fine. How are you, Commissioner?
I'm very good, thank you. So your motion is looking to extend the term of this approval for 43 years, which I believe is would calculate to 2063 if we approved it today.
That's correct, approximately 2063. And that would be, we'd be decommissioned and gone from the property.
Okay. I think your motion indicates approximately a couple of years for that decommissioning process. That's an estimated time that would be required. Is that correct?
To the best of my recollection, I think we're estimating about a year for decommissioning, somewhere in the range of 2 years for permitting, building permits and actual construction. So it's a couple of years on the front end and then approximately a year on the back end.
Okay. So congratulations on your PUC approved power purchase agreement. Can you tell me what the term of that agreement is? It will go into, I think you indicated it will go into commercial operation in approximately 2 years from now. So that would be 2022. What would be the term of the power purchase agreement?
So on this, Commissioner, and it's not that I want to drag this out, but I would like to be able to defer that question to Lawrence Green, who is the project manager for the Ho'ohana project, because he is just much closer to the power purchase agreement.
That would be fine with me. Is he available?
He is available.
That's acceptable. He has, I believe, raised his hand, Mr. Green, right? Lawrence Green?
Lawrence Green.
Okay, I'm going to promote him to be a panelist. I'm going to swear him in. As he's being included as a witness, I do feel like I have to provide, though I do not need to avail the other parties. I mean, the other parties don't have to avail themselves of the opportunity, but I do need to provide the other opportunities to ask the witness a question after this. Mr. Green, do you swear or affirm the testimony you're about to give is the truth?
I do.
Thank you. Please proceed. You were following the questioning?
Yes, I was. The original Ho'ohana PPA was 22 years. The current PPA that has been approved by the Public Utilities Commission is 20 years.
So if you go from commercial operation, that would be 2042 is the estimated termination of the power purchase agreement?
Correct, approximately, yes. For a 20-year operation period.
So if the power purchase agreement terminates in 2042 and it takes approximately 1 to 2 years to decommission, why do we need a permit that goes all the way to 2063?
So that's an excellent question, Commissioner. The short answer is that it relates primarily to the way that projects are financed. And so if I have to take my project and finance it over 20 years and presume that there's no value in my project after 20 years, then I have to charge a higher price to HECO, to bid a higher price to HECO, and then hope that my bid is accepted. But what all developers are doing these days is they're designing their pricing. I apologize for that. They're designing their projects around the design life of the equipment, and modern solar equipment has improved over the years, and now the design life for these kind of projects is 40 years. And so the idea is, in order to offer Hawaiian Electric the lowest possible price, is that we make a reasonable assumption that at year 20, the equipment is perfectly capable of generating electricity. The facility is in and running, and we're hopeful to come back to Hawaiian Electric with a compelling price for additional electricity at that time.
Does the power purchase agreement provide for a bilateral negotiation of an extension of the power purchase agreement, or would you be required to go through a competitive process again?
I know what I can tell you is that years ago, there was something called an evergreen provision for power purchase contracts. And with something like that, it was very clearly a bilateral negotiation. It wasn't necessarily a competitive process at all. What I can tell you is that our PPA does not have such a provision. We have to negotiate with Hawaiian Electric. I am not aware of the specific regulations that would be in place 20 years from now, how much latitude Hawaiian Electric would have to either engage with us bilaterally or have it as part of a competitive solicitation. But again, with all of the utility infrastructure in place, we feel that it would be a very compelling, we'd be able to offer a very compelling price, because essentially the plant will have been built.
So basically your working assumption is that either through augmentation of the battery storage every 10 or 15 years and replacement of panels as the warranties expire, you're going to renew the project, and your financing assumptions is based on a 40-year term. However, you're kind of hoping that I think that was your word, hope, that you could extend it through a bilateral negotiation, but you don't really know. You have no guarantee of that.
But we have no guarantee, and maybe it is a competitive process, but we have very good faith that the equipment will be in good shape, as you say, by standard operating and maintenance practices. We have a very, valuable project at the end of 20 years of operation, and we feel that that it would be a disservice to the ratepayers of Hawaii to simply pretend that that equipment wouldn't last that long, and then consequently have to provide Hawaiian Electric with a higher price, which of course in a competitive solicitation, that's not what our competitors are doing. They're also providing for a reasonable expectation of the equipment life, and so this is the standard in our industry right now.
So in the event that you are unsuccessful, and that and maybe this is a question to Ms. Lim, in the event that the project is unsuccessful in getting an extension of the power purchase agreement, would you be willing to initiate the decommissioning process and returning the land to its original intent, and basically terminating the interim permit sooner?
So our representation is that the request that we're making is for the solar farm the way that it's been described. So if the solar farm is no longer operating, substantially in the way that we have represented, then it would be terminated. And that's actually maybe a representation that you'd want to hear from Mr. Green rather than council.
Well, I think it's the owner of the project that would have to commit to. I'm looking to restore the land to its original condition.
Yes.
Under the provision that you're unsuccessful in getting an extension to the power purchase agreement. We wouldn't have to wait till 2060 to occur.
No, that's correct.
Just checking, Ms. Lim, are you or Mr. Green able to bind as to that representation?
I personally am not able to bind the project company, but I can say that our agreements are that once the project is no longer in operation, we do have to remove the project. So, I think that it's hard to say what the utility market is going to be like 20 years from now. It's most likely going to be Hawaiian Electric with the same kind of, structure. In other markets, we would have other ways to potentially have the project in operation that wouldn't rely on a single utility off-taker, which is the case in Hawaii right now. But I do think that I'm very confident to say that if we are not able to continue with the project in operation, selling to someone who is, 99.9 going to be Hawaiian Electric, that we would have to remove the project, or we agree to remove the project.
Yeah, my question was, I understand you agree to it and you're committed to that, but would you do it sooner rather than later?
Oh, so in other words, not let it set 5 or 10 years before removing it.
Not let it set 13 years.
Right. I would agree to move it earlier. I think that it's, again, subject to what the market looks like in 20 years. I'd like a little bit of time to try to get a contract for a little while, but give us a reasonable amount of time. And if that's not working out, we'd have to remove the project.
Okay. Mr. Green, did you see Mr. Overton's testimony yesterday?
Yes, I did.
Do you recall in one of the visuals he was describing the interconnection to the overhead transmission line?
Yes.
And my presumption is, maybe unfairly, that he was describing a proposed interconnection in the substation adjacent to where that existing transmission line is?
Yes, the 138 corridor runs within tens of feet of the property boundary, and we would break the line, the existing line, and loop that through the new Hawaiian Electric substation.
Can you confirm whether or not the interconnection requirement study that Hawaiian Electric requires has been performed and accepted yet?
It's still in process.
Do you have an expectation of when that would be completed?
We're pretty close now. I've said that for some time, but we are working very closely with Hawaiian Electric. They've been very good partners on this project. And so will it be October? I think so. Will it be by the end of the year? I'm certain.
But you don't see, at least up until this point in time, any potential problems that would necessitate an alternative interconnection?
No, I think that, you know, with the 138 kV lines right there, I cannot foresee any circumstance that we would have to build a Gentie line someplace. We will interconnect into those circuits that are right next door to us.
Okay, thank you. That's all the questions I have, Chair, and I'll pass the mic. Thank you.
Thank you, Commissioner Giovanni. Just procedurally, I want to make sure to check before we let go of Mr. Green. I want to, because he's now been brought in as a witness, are there any questions for Mr. Green from HALEKUA?
Well, Mr. Chair, this is Stephen Chung. I don't have questions relating to the power purchase agreement. I would like to ask Mr. Green questions regarding their intentions with respect to regional drainage.
Is there an objection, Ms. Lim?
Yes, John Minot for Ohana.
Mr. Minot.
Yes, so I think those types of questions would go beyond the existing scope of questions from the commissioners. So this is not the appropriate time to have those questions from our.
That tends to be my instinct, Mr. Chung, that I would want to limit questions to the matters that the commissioners had raised with Mr. Green.
Mr. Chair, all we want is a statement from the MAUI as to whether they intend to perform the obligations of the landowner with respect to drainage.
Well, again, that's outside the scope of the questions that have been posed to this point.
I'm going to rule that that goes beyond what you need to. Do you have any other questions for him, Mr. Chung?
I do not.
Okay. City and County, any questions for Mr. Green?
No questions.
OP.
I did have questions regarding the water line. I don't know if it's something the commissioners want to ask about the water line so that we could proceed.
You wanted to ask Mr. Green about the water line, which is also outside what commissioners asked.
If I may, you know, consistent with what my partner, Mr. Minot, said when objecting to Mr. Chung's questions, we would state a similar objection. But I also note that my understanding is that OP will have an OP witness, and my expectation is that the OP witness would want to discuss the filing OP made yesterday morning that has an item in it regarding the water line. So I believe there will be later opportunity for discussion about the water line.
Okay. I suppose the question here is are we going to have a chance to hear from the petitioner's witness on matters that are substantive to our deliberations? Commissioner Chang.
Thank you, Mr. Chair. I was going to ask exactly the question you have. The way that the petitioners have presented, they've sat on their filings, which we appreciate, and then we've opened it up for the commissioners so that we are limiting the questions of the parties only to questions that the commission raised. Will there be an opportunity for the other parties to raise questions beyond what the commissioners have raised so that a full record is developed?
Can you restate your question, Commissioner Chang?
Yeah. No, my question is, the petitioners have rested on their filings.
Correct.
And then we've opened the questions up to the commission. But based upon the objections of petitioner's counsel, any questions that are beyond what the commissioners have raised is beyond the scope of the witness's ability to testify. So will there be an opportunity for questions to be raised by the other parties that the commissioners may not have raised, so that we ensure that we have a full record? So it's more of a procedural question.
Right.
Will the parties, HASECO, OP, and DPP, have an opportunity to raise questions to the petitioner's experts, because they've chosen not to put on their case, which we've all agreed to? But will the other expert witnesses be available for the other parties to question and raise those issues that the commissioners have not raised?
So I understand your question.
Okay.
And I certainly share the desire that I have a desire that we make a decision on this docket today, if for many reasons, including the fact that a non-decision might imperil the project. I also have a desire to have, obviously, a complete and full record. I do believe that all of the parties have had the chance to offer argument, written argument, rebuttal, or responsive arguments to offer witnesses that they feel are doing things. But Mr. Collin, our Attorney General, you have some guidance for us on this matter.
Have the other parties had a chance to call witnesses already?
No, not yet.
So if they wish to, they could call these same persons if they're willing to come forward?
I'm sorry, was that a statement or a question?
That was a question. Are these same persons who they have questions for now, which we've ruled as beyond the scope, are they willing to be witnesses for the other parties?
Hostile witness, presumably.
Well, it would actually be direct testimony, but you could declare them as, hostile and witnesses.
So, to be really clear, Mr. Attorney, Deputy Attorney General, I'm seeking guidance here, not questions. If other commissioners wish to, this is, the overall issue we're facing, right, is that motions are generally simple. The more that we start to devolve these motions into highly contested case-like procedures, the more complex our proceedings become, the more difficult it is to make good use of our time. Commissioner Okuda.
Thank you, Mr. Chair. I believe you as chair have the discretion to manage the docket to use the time efficiently. I would just ask that in the interest of efficiency, if someone is going to want to call someone as a witness, and we certainly don't want to limit anyone's ability to do so, that an offer or proof be made. In other words, the person who wants to call a witness tell us what they anticipate or expect the witness to say, and then maybe the other counsels involved would agree, if called, that witness would say that. And so, in other words, we can get to the heart of the matter and we don't have this turn into a fishing expedition. Nothing wrong with fishing expeditions, but we're talking about efficient use of time. So my request would just be that you have the discretion to give people leeway, but if questions are going to be asked of a witness, an offer of proof be made and a response from the other parties to find out whether this line of questioning really is in contention or not in contention. Thank you, Mr. Chair.
Thank you, Commissioner Okuda. Mr. Lau.
I do agree with Commissioner Okuda on that. You do have that supervisory capability as chair to determine.
So I both want to, remain grateful for the main petitioner resting on their written record, for also making their witnesses available for commissioners' questions. I do want to make sure that we do not procedurally err and unfairly prohibit another party from asking a reasonable question of one of your witnesses that you plan to present, who would be able to answer a question that would help us establish a full record in this matter. I also intend to not sort of, as the term that Gary Okuda used, allow for fishing expeditions. Could we proceed assuming good faith in this manner, Ms. Lim or Mr. Minot?
Yes, thank you, Chair. We do agree that you ultimately have discretion to manage this process. I would point out that the procedures established for this hearing did set up deadlines, and we submitted written direct testimony that was fully available to HALEKUA and the other parties. They did respond. They filed declarations. There was also a subpoena process if somebody decided they needed to call an adverse witness. So the process or procedure that I believe Commissioner Chang alluded to earlier, our view would include appropriately responding to our written direct testimony, and if it was in some manner delivered such that they could not fully respond, then it would be on them to issue appropriate subpoenas for persons that they would want to call. So that's how we would look at it, strictly procedurally.
Mr. Chung, do you have a response?
Thank you, Mr. Chair. So all that HALEKUA is looking for is confirmation of what we believe, which is that the move-on does not intend to comply with the drainage requirements that were approved by the Department of Planning and Permitting in 1996 in the Drainage Master Plan, that the move-on is taking the position that it's only a lessee of the property, not the landowner, and therefore has no obligation that the landowner may have. We just need that confirmation. If Ms. Lim would confirm that, then we would have no questions for any of their witnesses.
Is there a commissioner who wishes to raise that question? Commissioner Giovanni.
I'm happy to raise that very question. Do I need to repeat it, or can I just say that?
Please don't.
Pardon me?
Please don't.
Thank you.
Mr. Green.
So as not to have to repeat the question, what I am doing is I am managing the stormwater on our site and have designed a stormwater plan that complies with what I'm required to do on my site. I'm not handling stormwater for other parties.
Commissioner Okuda.
Mr. Chair, all of the colloquy and Commissioner Giovanni's question actually raised the question I was going to ask. Thank you, Chair.
Okay. Commissioner Chang?
No, I want to move on to another question for Mr. Green. All right.
Oh, okay.
Is that?
I thought we were, other than this, done with questions for Mr. Green.
Yeah.
But
I know. I
if you still have one, please do. But before we do, there was a direct question that Mr. Chung expressed a desire to have answered. I take Mr. Green's response, well, not a direct yes or no, as a full answer. It was not a yes. It was not, yes, we intend to follow the 1995 order. It was, we intend to follow what we believe we are legally obligated to follow. And so it's my understanding from the statement of the witness that if I'm phrasing Mr. Chung's desired information correctly, the answer is negative. The petitioner is not intending to follow, fulfill the landowner's obligation under the 2015 order.
If I may, Mr. Chair, that I accept that.
Thank you, Mr. Chung. Thank you to everyone for helping us through this sticky wicket. Ms. Chang.
Okay, I'm going to keep my question very short. And Mr. Green, it's really a yes or no. Condition B1, Royal Kunia Ag Park non-potable water connection. And my question is,
Yes.
is Ho'ohana going to fulfill this condition?
Yes.
Okay, very good. That's it. Thank you.
Questions, commissioners, are there any further questions for Mr. Green? Ms. Apuna, was the question that you had concerned about the water line sufficiently answered in the response to Commissioner Chang's question?
I very much appreciate Commissioner Chang's question. I would just like to clarify with a question to Mr. Green whether you, if Ho'ohana is committing to the condition B1 that OP has provided in its revised Exhibit 1.
I think I heard the question. And you're referring to the revision that was received right before the proceedings started yesterday?
Yes.
We are in agreement.
Thank you. Thank you, Chair. No further questions.
Okay, Ms. Lim or Mr. Minot, any redirect of Mr. Green?
No further redirect.
Okay, thank you very much, Mr. Green.
Thank you. Thank you all.
We are now back to the main process of any further questions for the petitioner at this time. If there's no further questions for the petitioner, we will move on to the beginning of the argument and witnesses from HALEKUA. Are there any further questions for the petitioner at this time, commissioners? Seeing none, Mr. Chung, will you give me an overview of how long you would like to spend on your argument and your witness?
If the chair pleases, Mr. Lau will be taking over this portion of the hearing.
Thank you for that clarification. Pardon me, Mr. Lau.
Good afternoon, Mr. Chairman and commissioners.
You might need to speak directly into your microphone. Your
okay.
Volume is, that's much better. Thank you.
Okay, thank you. We're just going to have Ms. Shireen Tam as our witness, who's in the waiting room right now. She's just going to summarize briefly her testimony, and she will then be available for cross-examination or questions from the commission itself.
Okay. About how long do you anticipate her oral testimony to be?
Her summary should take no more than 5 minutes at the very most.
Okay, well, let's start in on it then. I'm going to bring in Ms. Tam. You're being promoted to be a panelist. Please enable your audio and video, Ms. Tam.
Good afternoon, commissioners. Thank you for letting me in.
I will now swear you in. Do you swear or affirm the testimony you're about to give is the truth?
Yes.
Okay, Mr. Lau, it's your witness.
Good afternoon, Ms. Tam. Are you the same Shireen Tam that submitted a declaration to this commission comprised of 4 pages of statements and 4 exhibits?
Yes.
Why don't you please proceed with your summary of your testimony, please?
Thank you. And thank you to the commissioners. We were very appreciative of Ho'ohana's response to our filing. The additional information that they provided alleviated the concerns that we had about the 138 kilovolt line connection point. We took comfort in seeing their landscape plan and confirmation of what they had orally told me a few days before their responsive filing about the natal plum hedge that was intended to be placed to provide some sort of screening from our planned future homes. The one issue that still remains a tremendous concern for our ability to move forward with the affordable and workforce housing we have planned is whether they will be consistent with the drainage master plans that are currently in place for that project, and that all of the developers in the area, including us, HRT, and their potential buyer of Jupiter, we have to base our development and do our due diligence based on what has been approved by the city in determining what kinds of costs, infrastructure costs, will be required. And we discovered after they had done their initial filing that their plan did not appear to be consistent with the drainage master plans. To help the commissioners, I took a screenshot of the different drainage master plans that are part of the record to make it easier for you folks to see compared with the 2015 solar farm plan versus what they have before you today. If you will permit me, I can show that to you
Ms.
to
Tam, I
identify
believe you
what we're
have the
talking about.
ability to share screen.
Okay, thank you.
Please refer to whatever specific reference in the record so that it's clear what we are looking at.
Okay, can you see my screen now?
For the purpose of the transcript, we can.
Okay, so this is from the 1991 Drainage Master Plan.
The figure on the far left, okay?
Yes. Okay, so that's from 1991. And as
And
you'll notice,
that's in the record.
That is in the record, Exhibit 5 that Michael Lau submitted to the commission.
Yeah.
Okay. And you'll notice there is a detention drainage basin that's shown in 1991 that's on what is today parcel 52. The next exhibit is from the 1996 Drainage Master Plan that was also part of Exhibit 5 submitted by Mr. Lau. And it also includes this drainage basin on parcel 52. And this was Ho'ohana's exhibit number 28 from their response to our filing. And the orange was the 2015 footprint of their solar farm at that time. The blue outline represents what they say will be their current solar farm plans that's before you. And in this area here is where that drainage basin would have gone. And what HALEKUA is asking for is that there be some space provided in this general area here along their Makai boundary with the existing golf course. This is our property right next door, so that the drainage master plan flows of 300 CFS can continue to be conveyed as called for in that drainage master plan to an existing culvert to the golf course. Now, we did have a conversation with Ho'ohana a few days ago. They made an offer to us about being able to possibly provide 75 feet of space to accomplish this goal. Our engineers are looking at it, but we do not have a formal agreement in place yet. But resolving the drainage issue is our biggest concern.
Is that the conclusion of your testimony, Ms. Tam?
Yes, thank you for your time.
Okay. The witness is available for cross, starting with the petitioner.
Thank you, Chair. This is John Minot. I represent.
Good afternoon.
Good afternoon. Now, in your declaration, you state that HALEKUA acquired parcels 71, 70, and 78 recently from RP2, correct?
Well, we acquired parcel 71 from RP2. I believe the other two are from HRT.
Okay.
And sorry, Mr. Minot and Ms. Tam, I'm just going to note we're at around 12:51. I will break it around 1 o'clock, depending on, well, I will break it around 1 o'clock. So.
Thank you.
When you acquired the property from RP2, was it your understanding that HALEKUA assumed all the obligations that ran with the land?
We understood and are ready to fulfill all of the obligations called for in the existing DNOs on this property.
As part of your due diligence, did you review the 2015 solar farm order?
Yes, I was aware of it.
And so HALEKUA was aware that a solar farm proposal was being renewed for this parcel 52 before you closed on the transaction.
We were aware that there was some activity going on. We did not know that you were as far along as you actually are.
You're aware that there was efforts being developed to renew the solar facility on the adjoining parcel, correct?
Yes.
Did you ever reach out to Ho'ohana about any drainage concerns before HALEKUA closed on the property?
We didn't think we needed to. Our experience has been that all developers are required to comply with the existing approved infrastructure master plans. So I was taken aback to discover that there might be an inconsistency with the drainage master plan that's on the record, sir.
So my question is, did you do anything to reach out to determine whether Ho'ohana would do anything about drainage concerns that you may have before closing?
Not before closing, because we discovered the issue after closing occurred.
You didn't do anything before closing to inquire about drainage handling over parcel 52, correct?
Correct, because we believe they would be forced to comply with the existing approved drainage master plan.
Are you aware of any recorded drainage easement running across 52 in favor of the HALEKUA parcel?
I'm unfamiliar with that.
Are you familiar with what the term easement means?
Yes.
Do you know if there are drainage easements in favor of HALEKUA in the petition area?
I'm unfamiliar with that.
Right, so from your understanding of the 2015 solar farm order, are there obligations that are required of the landowners contained in clause A1?
There are obligations to provide offsite infrastructure to the Department of Agriculture's agricultural park.
Okay, was it your understanding that that related to the landowner obligations as stated in A1?
I believe it says landowners.
Did you also understand that the solar farm's obligations were stated in conditions B2?
Are you referring to the irrigation line again? Yes.
Oh, that would be one of them, yes. But the conditions in section B of the 2015 order related to the Ho'ohana solar farm, correct?
From 2015, yes. I understood that Ho'ohana had certain obligations to provide the irrigation line for the Department of Agriculture's agricultural park, as well as to maintain that line.
Does the 2015 solar farm order state anything about handling of stormwater drainage?
Not that I'm aware of, but again, my experience has been that you have to comply with existing infrastructure master plans, including drainage, and the 1996 DNO does specifically require that all the landowners work together to accomplish dealing with the drainage.
Right, but your testimony is you do not know or do not recall of any provision in the 2015 order that addresses how Ho'ohana would handle its own stormwater drainage, correct?
Its on-site drainage is different than the entire area's drainage master plan compliance.
All right, so reading between the lines there, you understood that there was some provision for how Ho'ohana itself would handle its own stormwater drainage in that 2015 order, correct?
That's a requirement for any development that's going to move forward.
So you saw that or were aware that that existed in that order?
I'm just aware that that exists in general. I don't know if it was specific to the 2015 order. I know that it was specifically referenced in the 1996 order.
Now, in your Exhibit 1 that you attach in the declaration submitted, there's a conceptual plan. Did you do anything to designate a drainage area on that exhibit?
Not yet, no. And this is still being worked on because we need to account for changes in the different stormwater handling requirements on our site.
Let me shift now to the Department of Ag MOU.
Mr. Minot, I'm just going to check in terms of not disrupting your flow later, but give me a sense of where you're trying to go and how much time you might need.
A few more questions. If I could just ask a few more, then take a break and we can come back.
All right, so you want to be able to conclude your questions prior to the break? Is that what I'm hearing you say?
I've got a few more questions. If we could take a break and then I can finish up just after the break.
Okay.
Hopefully.
Sure. We'll stop in 2 minutes.
Okay, so Ms. Tam, to your understanding that HALEKUA assumed all of the RP2 obligations under the 2020 MOU with the Department of Agriculture?
Yes.
So it's your understanding that MOU is valid and binding on HALEKUA?
Yes.
HALEKUA,
We have had discussions with the, I'm sorry.
So is it HALEKUA's present intention to honor all of the obligations contained in that 2020 MOU with the DOA?
We've had discussions with the department to adjust the timeframes that are stated in that memorandum.
But with respect to the substantive obligations, your understanding is that HALEKUA will honor those?
Yes. We think everyone should have to fulfill the obligations that are stated in all of the existing DNOs.
As a landowner, HALEKUA assumed whatever obligations the predecessor owner, HALEKUA Kunia, had. Is that your understanding?
Yes.
Did you know that HALEKUA Kunia had assumed all of the infrastructure obligations for this petition area?
I'm unaware of any agreement that would have relieved the landowner of parcel 52 from fulfilling its obligations under the existing DNOs.
All right, so you're not aware that in 2007, HALEKUA Kunia had assumed all of the obligations for infrastructure with respect to this petition area?
I am unaware that there was any relief granted to what the LUC issued in its DNO. I am aware of several private agreements, but that does not provide relief from a decision that the Land Use Commission had ordered.
All right, so let me just back up just to make sure.
Okay, it's 1 o'clock. I'm going to call for a 10-minute break. We will resume at 1:10. Yeah, we have all our commissioners. Okay, we're back on the record. We're on the petitioner's cross of HALEKUA's witness, Shireen Tam. About how much longer, Mr. Minot?
I've got about 5 or 6 questions. Quickly, should be quick.
Thank you. Please proceed.
Thank you, Chair. Ms. Tam, you testified earlier that HALEKUA was unaware that Ho'ohana was putting panels in the lower part of parcel 52 before the closing of the purchase from RP2, correct?
No, I said I was unaware that they were going to be inconsistent with the drainage master plans. I could not tell from the initial filings if you folks have made some other type of accommodation for an engineered solution in place of the basin.
All right, but you didn't see a basin in the materials that were sent to you before the closing on August 4th, did you?
No, I did not.
Do you recall getting a copy of the initial motion with the exhibits?
So hold on 1 second, Mr. Minot. All of a sudden, Mr. Simon has started to screen share. Can you please explain?
Yeah, sorry. Yes, can we show exhibit 18?
This is petitioner's exhibit 18.
Yes, petitioner's exhibit 18.
Okay, yeah, give me a heads up first.
All right, so Ms. Tam, this is a copy of an email that was sent from Jennifer Lim. You were shown as a CC on August 4th. As I understand it, that was 8 days before closing of the purchase, correct?
Yes, that's correct.
All right. The exhibits that came with it included an Exhibit 5. Did you look at those exhibits?
Yes, I did.
Did you see on Exhibit 5 that the solar panels went essentially to the bottom of parcel 52 and that there was no drainage area indicated?
They didn't show a basin, but my understanding was the basin is needed when Robinson moves forward with a residential use on that property. The full-on basin may not have been needed just for the solar farms development at this time. And I could not tell what their
sorry.
drainage plans.
One moment, Ms. Tam.
Yeah, sorry,
Mr.
Derek.
Minot, please.
I think we
prior
jumped the
to
gun.
pulling up or referencing a exhibit, please let me know that you're going to do so and what it is. Otherwise, among other things, the transcript is not going to make a heck of a lot of sense.
Yes, I apologize. I'm sorry that did get up there too soon. If we could show the figure 1 that was referenced on the parcel. Do you recall, Ms. Tam, seeing this figure in that email
Yes.
package?
Yes.
You see on the far right of the shaded area, that would be the panel location, and there's no drainage basin area indicated there, correct?
Like I stated, I did not see a basin, but I also did not see any information on how drainage was going to be handled at all for that parcel. And we could not tell from this exhibit where the actual panels would be or any of the other details that we felt was missing that prompted us to file our response to your motion.
All right, so again, prior to closing though, you did not reach out and ask Ho'ohana how they were expected to handle drainage concerns that you might have, correct?
I did not ask Ho'ohana that question because we apparently wrongly assumed that they would know they have to comply with the existing drainage master plans. They don't need to necessarily do a basin, for example. They could have chosen some other type of solution, and we were unaware of that. We were not particular about how they chose to deal with it. We just think that it's critical that they abide by and account for the flows that are shown in that approved master plan.
When you filed your opposition to this motion, did you raise anything related to drainage that you are raising now?
We did not know that they were inconsistent with the drainage master plan until after my motion was filed. My declaration was filed.
So in the opposition itself,
excuse me.
right, the opposition itself did not raise anything about your drainage concerns, correct?
That's correct, because we did not know that Ho'ohana was being inconsistent with the drainage master plan at that time.
I have no further questions. Thank you, Chair.
Thank you, Mr. Minot. City and County, Mr. Takahashi, do you have any questions for Ms. Tam?
No, we have no questions.
Thank you. Ms. Takeuchi Opuna.
Thank you, Chair. We do have a couple of questions for Ms. Tam.
Please
Excuse me,
proceed.
Dawn. Can you please keep your voice up? Thank
Sure.
you.
Okay. Thank you, Ms. Tam, for your testimony. I just have a few questions. Are you familiar with OP's revised Exhibit 1 that was provided to the Commission yesterday morning?
Yes.
And so is HALEKUA committed to providing the offsite infrastructure under the A1 condition?
Yes.
And does HALEKUA understand that the offsite infrastructure does include the non-potable water line appurtenances, for example, a pump system for the water line?
I'm sorry. Excuse me. I'm not hearing you clearly at all.
Okay, sorry. Ms. Tam, does HALEKUA understand that the offsite infrastructure under the A1 condition includes the non-potable water line appurtenances, for example, the pump system for the water line.
I understand that RP2 had designed a system that included the pumps, and my understanding was that Ho'ohana did not agree that they were required to provide pumps, just a strict water line.
And so is it your understanding that HALEKUA will cover the water pump system, the water line system other than the water line under condition A1 that OK is proposing?
We're agreeable to that.
Thank you, Ms. Tam. One more question. Is HALEKUA committed to providing a bond for the Ag Park offsite infrastructure?
Yes, we had made that offer to provide the Department of Agriculture with some comfort that this time they really will get the infrastructure that they need.
Thank you, Ms. Tam. No further questions.
Thank you. Commissioners, who has questions for Ms. Tam? Commissioner Chang, followed by, judging by smiles, Commissioner Okuda and Commissioner Wong.
Thank you, Mr. Chair. Thank you, Ms. Tam, for being here and or for Zooming and testifying. I just have a few questions, and this is related to condition A1. Are you familiar with that?
Yes, ma'am.
All right. So do you know who the landowners are within the petition area?
At this point, it is HALEKUA that owns the bulk of the Royal Kunia residential areas, with the exception of parcel 52 that's currently owned by the Robinsons. HRT continues to own the industrial parcel, but is in the process of selling it to Jupiter.
And is it your understanding that all the landowners are responsible for the off-site infrastructure?
Yes.
Do you know, or is HALEKUA a party to the MOU with the Department of Ag regarding the off-site infrastructure?
There was an assignment of that to us, and we have been talking to the Department of Agriculture about updating the timelines and deadlines that are stated in it to be more reflective of what we're able to actually achieve for them.
Do you know whether the landowner of parcel 52, the Robinsons, is also a party to the MOU?
I don't believe they are. There was just a requirement to obtain easements through Robinson lands to be able to provide the water line in particular. And the offsite infrastructure also needs to cross a little flag stem of the Robinson property also to reach the Department of Ag property.
Okay. So let me ask you a follow-up question on that, because so when I read condition A1, it says within 6 months of the date of the commission's order, the landowners, (S), within the petition area shall finalize the amendment to the MOU dated 1993, 207, 209, 212 with the Department of Ag and comply with this amended memorandum of understanding. So what I heard you just state is that the Robinsons, owner of parcel 52, is not a party to the MOU. Is that correct?
I don't recall seeing them sign the MOU between RP2 and the Department of Agriculture.
Okay. All right, very good. Thank you very much. I appreciate your answers.
Commissioner Wong.
Chair, do you want to oh wait, I thought Commissioner Okuda was before me.
You know, he normally raises his hand, and I was just going by his smile. Commissioner Okuda?
Thank you, Mr. Chair. I don't mean to cut in line. I was just smiling. But since you called on me, Ms. Tam, if I can ask you this question, these are more cleanup questions. First of all, the petitioners submitted written direct testimonies. These are petitioners' exhibits 42 through 49. Does HALEKUA dispute any of the statements made in those exhibits, the direct testimonies identified as exhibits 42 through 49?
I'm sorry, Commissioner, I'm not familiar enough with all of their exhibit numbers to know specifically which ones you are referring to. If you don't mind, I can go look them each up to see.
Oh, no, I'm just trying to find out maybe if right off the top of your head, there was something in any of these direct testimonies which stuck out, which you objected to. But if you don't have any specific knowledge, that's fine also.
The only thing that I'm particularly concerned about is to make sure that they comply with the drainage master plan. If we're able to resolve that issue with Ho'ohana, we, just like all of you, it sounds like, are in support of the solar farm and understand the need to provide for and attain the state's energy obligations in that way to go to renewable. We're not trying to stop the farm or anything like that. We just want to make sure that everybody is treated equitably and held to comply with the existing infrastructure master plans and the obligations in the DNOs.
Okay, and that actually led into my second question. So you actually answered that, which is the only objection that HALEKUA is raising is issues regarding drainage. And I'll to use the descriptions and testimony you gave, it's simply this drainage issue, if I can classify or describe it so generally. Is that correct?
At this time, yes, the additional information they filed in response to our motion adequately addressed the questions and concerns we had about the 138 kV line, as well as the landscape buffer that they're talking about. That was not, the landscaping plan was not included in the original filing.
Okay.
Nor was information about the connection. So those two issues are now done. It is just the drainage that we are most concerned with.
Okay, and would you agree that the Land Use Commission, frankly, is not the end all when it comes to enforcement of drainage obligations or drainage conditions? Let me be more specific. If such a condition existed on an adjoining parcel, you as an adjoining landowner, if you're benefited by that condition, could go into court to get a court order to enforce that condition, correct?
Yes, we could, and we are willing to do so, but we understand that could impede their ability to meet their obligations under the power purchase agreement. So we're hoping to find a way to resolve this without having to go to that extent. If they just comply with that condition 16 that's already in the existing DNO, then I think that we can work things out amicably.
Is there something in the record from an expert which provides an opinion or statement that the solar farm or the drainage issues there is not in compliance with any condition? Has HALEKUA submitted a statement or testimony from an expert indicating there is such non-compliance? And let me tell you the reason. Go ahead, I'm sorry.
We did not submit something like that from an expert. We had asked Ho'ohana after we got the additional information about it, and they said that they did not think they were required to. So we're asking again about making sure that everybody has to comply with what is already in the existing DNOs issued by the commission, which includes coordinating for drainage.
Okay, well, I'm just trying to make sure that whatever decision we make is not based on speculation, because we have to make it based on evidence in the record. Can I ask this? Your current engineer is still RM Towell, correct?
Yes.
And since there really is no client engineer privilege, have you been advised by any of your engineers that there is a risk of harm to your property, HALEKUA's property, from any drainage issues?
If the drainage master plan is not respected and the 300 CFS that's supposed to flow and connect to existing pipe culverts that are on the Robinson property to the existing operational golf course, yes, we will be forced to figure out some other solution. And that
Well-
has an adverse effect on us. And we don't have an answer for that. We're just asking that they be forced to comply just like anybody else would be to respect the existing infrastructure master plans.
Let me ask a slightly different question related to that a little bit more broadly. You are aware that whether or not there is a recorded condition recorded condition or recorded requirement, adjoining landowners have a duty not to negligently or carelessly alter the natural flow, causing damage from water to downflow owners, correct?
Yes.
Is there any evidence in the record that you can point to that the solar farm property, for lack of a better description, is contemplating doing anything which indicates not just a speculative harm, but a reasonably foreseeable harm in the future? Because I don't see any such report in the record, so maybe I didn't read everything carefully, but can you point to where in the record there is evidence of the conduct which we can conclude will show foreseeable harm?
Their site plan does not show the drainage basins called for in the drainage master plan. We did not want to assume that they were choosing to not be consistent with the plan. They may have had some other engineered solution, so we asked about it. And at that point, they did not have some other way, and they did not feel that they were obligated to conform with it. The discussions have advanced to the point now where Mr. Green has sent me an exhibit that says they could provide enough space for us to put in an engineered solution to satisfy and be consistent with the drainage master plan. We just have not been able to finalize that. Our engineers are looking at it. If that occurs, allow us to have a safe way to convey the flows shown in the plan to tie into existing infrastructure per that master plan, then we're good. We're just not at the point to have that agreement in place yet.
Okay, then my final question is, would I be totally wrong? Would I be totally wrong if I were to conclude that perhaps your concern right now is not, as we say in the law, ripe, R-I-P-E, that it's something that might be of concern in the future, might not, but we really can't tell one way or the other because people are still talking, which is really, really good. You know, we should really talk things out as much as possible. But that's where we are right now. Maybe everybody's gonna be good neighbors and, you know, everybody seems to have respectful, competent advisors and engineers that, you know, it more probable than not, this can be worked out in the future. That maybe this issue right now is premature and not right. Would I be totally wrong to come to that conclusion?
Well, Commissioner, if I may ask, if the solar farm is allowed to proceed the way that their plans are shown, and there is no accommodation or requirement for them to accommodate drainage that is spelled out in existing infrastructure master plans, and they proceed with trying to put their panels on, and at that point it gets litigated and they are affected, how are we supposed to be able to proceed with our development plans? This is $1 billion project that's going to provide more than 1,000 jobs as well. The state has a priority on doing affordable and workforce housing. We would be adversely impacted if they do not have to conform the way that every other developer on the island is required to do.
I'm sorry to interrupt, but that wasn't my question. My question was because of the existence of these discussions, as far as I can tell, nobody is breaking off talks or anything like that. My question was just a really simple question. Would I be totally wrong to conclude that maybe the issue is not ripe at this point in time?
Well, Ho'ohana, Mr. Green admitted that he does not believe that they need to perform or comply with the 1996 Drainage Master
I think, Ms. Tam, it can be yes, no, or I don't know.
Yeah.
Well, I think a decision from you folks today that would require them to comply will have a extremely beneficial effect on both sides.
I'm sorry to interrupt, Ms. Tam, but the chair is right. I wanted to keep my question simple. It's either yes, no, or I don't know.
The question is the issue ripe?
Yeah, or would I be totally wrong to conclude that this is premature right now? The answer to the question is either yes, no, or I don't know.
You make them comply, then I don't think that there's an issue. If you're unwilling to do that and we need to wait further, then I think you're doing harm to our project.
Okay, I will evaluate your answer based on what it is. Thank you, Mr. Chair. No further questions. Thank you, Mrs. Tam.
Thank you. Commissioner Wong.
Oh, thank you, Chair. Mrs. Tam or Miss Tam?
Either is fine.
You know, it's right after lunch, so I kind of ate too much loco moco. So please excuse me on this first question. So when you're talking to OP about something about bonding, what is that? Can you explain that to me? About you guys will be okay with bonding?
My understanding is some of the prior landowners of the parcel that we own today had made a lot of promises and said that yes, they would meet their schedule, yes, they would install the infrastructure that the agricultural park needed, and then didn't do anything. And I can understand that they feel very doubtful about what is going to make us different than who has come before. So we said, to provide you that assurance, we'll do those plans. This is the time frame we think we can do it in, and we're willing to put a bond in place so that if for some reason we fail to perform, they are still going to be able to get the infrastructure that they need to reach that agricultural park.
Okay, thank you. That explains a lot to me. The next thing is, you know, you were talking to Commissioner Okuda about master plan. What master plan are we talking about? Existing master plan?
There's the drainage master plan. There's an existing drainage master plan that covered the entire area, agriculture park, industrial park, all of the Royal Kunia residential areas, including increment 3, which is today the parcel 52 for Ho'ohana Solar Farm.
When was that made?
The last updated one that's on the record is from 1996.
Oh, so before I was on this commission then. Sorry, I was trying to look for it like in 2015, 2018. I guess it was 96.
The prior drainage master plans were a part of the facts that were considered for the 1996 DNO that was issued on this property.
Okay. But you said something about you're planning to do a new plan or something?
The city generally will ask that you provide an updated drainage master plan, especially for one that is as old as this one is, to reflect what the current uses are going to be.
So the question I have, well, let me give you a step back. So we just did Hawaiian Memorial Park, and there was issues about rain and runoff and all this. And they talked about, you know, the city has a limited amount of drainage, water basin. You know, Commissioner Giovanni knows more about this than me. But so Commissioner Giovanni said, you know, we should get it bigger because we're having more 100-year floods. So this drainage plan will be updated because there's more 100-year floods or something like that, correct?
Drainage master plan will take into effect the updated rainfall totals. I think in this particular area, the city calls it a plate 6 amount that the engineers will use to factor in how much capacity they need to provide in a drainage system in terms of basins or other stormwater treatment facilities.
Okay. So you know, I guess in 2018, we asked for a status report from Mr. Tanoy, or he was representing his company, RP2 or RM Tao. So you guys,
I'm sorry, I lost you there, Commissioner.
Oh, so, David Tanoy gave us a status report approximately in 2018. And so, because we wanted to know what's happening, pretty much. So, I mean, are you guys going to give us this status report also to keep us updated, or do we have to do a motion order to show cause because we don't get anything? I mean, how will we get this information?
There is an obligation to provide an annual status report to the commission as well as to the city about where we are in satisfying the conditions of the existing DNOs.
Mm-hmm.
So we would continue to provide that annual report to you.
Okay. Oh, thank you. I mean, sorry, I just didn't know these things. Then the other question I have is, for the bonding issue again about the water line that everyone's talking about, or the MOU or whatever everyone's talking about. So what is HASECO's belief and the obligation for this funding? Is it your obligation and the landowners? Is that for the MOU or something like that?
The Fourth Amendment to that MOU deals with providing the offsite infrastructure to the agricultural park. And we told the Department of Agriculture that we wanted to be able to update the timeframes that are shown in the Fourth Amendment to something that we know we can perform to. And we would be providing them the permanent infrastructure rather than temporary water, power, sewer to the agricultural park. That's because we're the ones who are actually developing the roadways that these utility lines would fall under. So once we build it, it's theirs. During the period before it is built, we're willing to bond it so they have proof that it's going to be there, and they are able to pursue the additional funding that they may need from the legislature to take care of the rest of their agricultural park development.
So this MOU is between you and DOA. Is that correct?
The current MOU was executed between RP2 and the Department of Agriculture. It was assigned to us when we acquired it, and we've been talking to the department about updating it. We understood that the department wanted to put it on the record. I believe it's supposed to be scheduled for the commission to review it at one of the upcoming meetings. We had asked that it be updated again to reflect more realistic timeframes that we believe we can deliver on.
Okay, so I guess the issue is more the water and all this MOU stuff. Robinson or Ho'ohana has no say in this then. They just got to follow up. They got to do it then because they're not a party.
My understanding was there is a 2015 DNO that specifically called out Ho'ohana as being responsible for providing and maintaining that irrigation line and for obtaining the easement necessary through the Robinson lands to run that line to the Department of Agriculture's Ag Park.
But not to
And I
build it.
believe that that's the thing. The initial motion that Ho'ohana had filed, we thought seemed to say that they were trying to not have to fulfill that obligation anymore.
Sorry,
we think that everybody.
If I may, I thought we put aside the issue of the water line, right? Your only dispute is with drainage.
My dispute is drainage, but he was asking me about it, so I was just trying to answer his question.
Thank you, Chair. Then I guess the last question I have is, that motion you filed in opposition, citing a subsection 1570E, calling for a counter affidavit and memorandum in opposition. Is it a motion or is it something else? Is it supposed to be considered a counter affidavit or a memorandum?
I think that's a question better answered by Mr. Lau.
Oh. Commissioner Wong, I think our sole purpose was to get onto the record our opposition to some of the matters that were going to be brought before the commission. Whether it should be a motion or just a memorandum in opposition, I don't think we have a preference. So if we mischaracterized and did not choose the appropriate provision, we apologize.
Okay.
But our main goal was just to make the point that we were concerned about a couple issues that they had raised, and we needed more clarification and information on the 138 kV line and the proximity of the solar farm to the residential areas.
Okay, so now that all that's, I guess, Chair reminded me, that's put aside and we're just dealing with just one item, correct?
That's correct.
Okay, thank you. That's all, Chair. Thank you, Ms. Tam. Thank you, Mr. Lau.
Commissioner Giovanni, followed by Commissioner Ohigashi. And then, sorry, Commissioner Axon as well, were you indicating? So Giovanni, Ohigashi, and Axon.
Thank you, Chair. I'm not sure if my question goes to Mr. Lau or Ms. Tam. So I'll ask it and then either of you can answer it. So under the hypothetical that the solar project does not exist, and would it be your position that the landowner has the responsibility for compliance with the master plan relative to drainage on parcel 52?
I guess from a legal standpoint, the answer is yes.
If the land, if the solar project does exist and they obtained a lease from the landowner and that lease conveyed the responsibility for compliance with the master plan for drainage, is it your understanding that the project owner would be responsible or the leasee would be responsible for compliance?
I think that was one of the issues that we had raised in our opposition, because it appeared from the pleadings that were filed by Ho'ohana Solar that because they were merely the lessee and not the landowner, that they were under no obligation. And our purpose in filing the opposition was really to bring that issue to a head, because it doesn't make sense that someone will tie up the land for 40 plus years and then say, oh, those obligations don't apply to us because we're not the landowner. Having a 40-year lease in Hawaii is just a little short of fee simple ownership. So that was our main point for raising that particular issue.
So I understand you raised it. What's your position on that point?
Well, certainly as the lessee, a long-term ground lessee, it should run with the land and follow the lessee during that period of time.
So I asked if it was explicitly in the lease that they would be required to fulfill that requirement. Would it be your understanding that it would be the project owner or the lessee's responsibility?
Well, the conditions run, in our mind, the conditions run with the land. So whether they are just a lessee or the fee owner, nevertheless, it goes with the land. So as a lessee, they have that obligation. And I believe the conditions from the land use decisions were recorded against all of the parcels in the petition area.
So it's your position, I'm assuming it's your position, I ask you to confirm or to agree or disagree, that the landowner is not responsible for compliance, it's the lessee that's responsible for compliance.
Well, I think the way we phrase it is and or. So it's either, one of them has to be responsible for it. Ultimately, the landowner, but our position is, given this is a long-term lease, the lessee is responsible for that.
So you don't care who does it, as long as somebody does it?
As long as someone's going to follow the terms of the master plan, that's all we care.
But in your legal opinion, in the absence of the lease explicitly addressing who is responsible between the landowner and the lessee, what is your opinion?
I haven't seen the lease, so I don't know what's contained in the lease, but certainly most leases would say you're subject to all of the encumbrances that that impact the land. So from my legal standpoint, it doesn't matter whether it's the lessee or the landowner. I would hold them equally liable and responsible for compliance.
Thank you. I have no further questions.
Okay, thank you, Commissioner Giovanni. Commissioner Ohigashi, followed by Axon.
I think my questions are slightly on similar lines, but I'm trying to grasp what exactly you want the Land Use Commission to do about this. Do you want a condition that says, hey, you guys got to follow the drainage master plan? You want a specific statement like that as a condition? Is that what you want? Oh, whoever can answer that.
I'll try to answer that. We don't mind the commission approving the petition subject to the parties filing an agreement resolving the drainage issue.
That's not my question. Apparently, it's not resolved according to your witness, Stam. All I'm saying is that I want to resolve this today. So I'm curious as what are you asking for?
Well,
and if you are asking for that, I'm not sure we're able to give that, because that would essentially be something akin to a declaratory ruling to make a finding that they're not in compliance with the drainage master plan, or make a finding that the drainage master plan is part of a condition that is required by the applicant and that required by the petitioner, and that they are in breach of that condition. So we're directing them to meet that condition. As I see it now, I'm more in line with what Commissioner Okuda says, that it doesn't seem like something ripe for determination at this point in time. So if you can tell me, what do you want us to do, Mr. Lau?
Okay. Well, first of all, Condition 16 from the 1996 decision and order clearly required the petitioner, in this case all of the landowners, to develop the appropriate drainage improvements and having the adjoining landowners cooperate in that development. So that's the first point. Second point, I think the point that Commissioner Okuda raised, is it ripe or not? I think we heard from the witness earlier today, Mr. Green, indicating that they did not intend to comply with the drainage master plan. So I think I beg to differ with Mr. Okuda, but I think the issue is ripe, and therefore we would request that the commission, as a condition, require the parties, require Ho'ohana to comply with the drainage master plan requirements.
So it sounds like you want us, or you want us to enforce the term of the condition. Is that right?
Yes.
And if we do that, don't we run into a problem with the issue of substantial commencement of the entire project? Because my understanding is this was one project when it was approved. Well, and broken up into about 4 parts, I understand. And some of it has been developed. There is some, and technically, I think the Supreme Court has indicated to us that we do not have enforcement powers. So I am not sure what you're asking for right now can be granted. So why don't you convince me that you can, and tell me what you can.
Well, you know, I think there's an interplay between the Land Use Commission and, in this case, the City and County of Honolulu. As an example, the Land Use Commission imposes affordable housing requirements in any of these urbanization when there's going to be residential development. So condition number 1 of the Land Use Commission's order states that they shall shall provide affordable housing. Now, the Land Use Commission doesn't necessarily enforce or police the affordable housing, but that's an issue that plays into the hand of the city when they go in for the zoning. So in that situation, the city has the jurisdiction of handling that. Similarly, in drainage, I think DPP's filed in this proceeding their comments and indicating that it was necessary for the parties to work out these issues relative to the infrastructure. And so they have proposed that as a condition of them obtaining their building permits, that a memorandum of agreement or similar type of arrangement be filed with DPP prior to the submission of building permits. So I guess, to answer your question, there is an interplay between what what the Land Use Commission says, as well as how the city would then, take over matters that are solely within their jurisdiction.
So, thank you, Mr. Lau. So that clears up my mind. I do not think that this is a Land Use Commission matter. I think it is properly placed before the city to make that determination as to whether or not the condition has been met and what necessary requirements they will require for drainage purposes. Thank you.
Commissioner Axon.
Thank you, Mr. Chair. Good afternoon, Ms. Tam.
Nice to see you again, Commissioner.
Some of my questions kind of pretty much answered in part, and still not, clear in my mind on some of the answers. So, but one is, who is ultimately responsible for this drainage master plan? Is it the lessee or is it the landowner? That I'm still not clear who is responsible. So, Ms. Tam, on your testimony, you mentioned that all the issues, all the HALEKUA's concerns were solved except the master drainage plan, correct?
Yes.
So, again, going back to who is responsible for this master drainage master plan. That's, I'm not a lawyer, so I'm gonna be dependent on those lawyers to answer that. But my other question is, you also testified in response to Commissioner Okuda's question about is HALEKUA going to be harmed if this project moves on without fix on a drainage master plan?
Yes.
Okay. Now, if we move ahead with this motion and did nothing about this master, this drainage plan, what is your recourse?
To take them to court, to appeal that decision, to require them to have to comply. The lawyers could give you the correct legal verbiage for that. But I understand that there are legal remedies we could pursue, but I also recognize that doing so will have an adverse effect on the solar farm's ability to proceed. That's why we're hoping to be able to resolve things more amicably.
Yeah, that's where I'm getting at. I just want to know, if you file, if you file a lawsuit on this one, what will happen? Give me examples. I know you mentioned about effect on the solar farm. Is there any other effects that you kind of, on your layman's interpretation, or for my sake?
If they don't comply with the drainage master plan and allow the 300 CFS that's supposed to be able to flow to the existing connection points, then I don't know how we're able to move forward with the development of our parcel that's right next door.
I'm talking about, if you file a lawsuit or if this thing goes to court. You mentioned about effect on the solar farm. What do you mean by that? Are you talking about they're gonna be delayed? You also mentioned about, the affordable housing is gonna be delayed. So I'm just kind of trying to figure out the costs if you do something now, or we don't do anything. If you don't do anything, what is the cost to the state, to the petitioner, to other landowners. Because I believe that doing something now is better than waiting for whatever happens later. So if there's nothing we can do right now, then so be it. I just want to kind of get some ideas on how to protect those lands, how to move on with this development. We're talking about, thousands of, employment for everybody, and also providing affordable housing to the state of Hawaii.
Well, if the project were my project and I did not have the clear ability to move forward with my development, I would not spend any money to proceed in the event that the court chooses to rule against me. That would cause delays. Now, perhaps the solar farm developer has a different point of view and is willing to take that sort of a gamble. And if they lose the case and we prevail, and they then have to remove panels that they have knowingly put in place of where an engineered solution could be installed for drainage, that would have an adverse impact. Yes, I think it would be far more beneficial to deal with this ahead of time, and I'm hopeful that we will get there. We're just not there yet. They just sent to me a little diagram of how much space they think that they can provide to us, and they've asked us to provide an easement for them that they need as well. I'm not sure if that answers your question.
Yeah, but I guess I don't have an easy answer for you or any answer for everybody, but I believe everybody understands that everybody's going to be taking a risk, whatever we decided today. And I'm talking about a big risk for everybody. Thank you, Mr. Chair.
Okay, Commissioner Wong followed by Commissioner Chang, but I need to do a time check here because despite the good efforts of the main petitioner, things are stretching out here. We need to take a break soon. Do you have extensive questions, Commissioners Wong or Chang?
I have one question, Chair.
Okay, Commissioner Chang, just one. Go for it.
Okay.
Commissioner Wong.
I guess this is the issue I'm really having trouble with. You know, the drainage plan was done in 1996, and I guess what I heard Ms. Tam say is they're doing a new plan that will also have to include new drainage and everything, because even EIS, because everything is stale. So what are we going to do? I mean, it doesn't make sense for us to, as Commissioner Okuda says, this sucker is not ripe. So why do we have to deal with this drainage thingy? Sorry, this is just a statement.
I think it's more of a statement than a question.
Yeah, sorry, that's it. I mean, that's how I feel right now.
Because I think the witness has expressed her thoughts on the matter. Commissioner Chang.
Thank you, Ms. Tam. You said you would prefer to find a solution, and you did receive some plans from Mr. Green
Yes.
on a potential drainage mitigation measure. So my question to you is, to avoid this ripeness and speculative issue, how long will it take for HALEKUA to review the plans to determine whether it is an acceptable drainage mitigation measure for your parcel 71?
We had told Ho'ohana folks that we thought we would need 2 weeks to be able to resolve whether it worked from an engineering standpoint, and then it was a matter of getting the lawyers all the way around to agree on the actual documentation.
Okay. Can I ask you, is it going to require DPP or Department of Ag review and approval? Is there anyone else that needs to review this solution between you and Ho'ohana?
I think to actually implement and construct The items that are in the utility corridor that they are asking permission from us for would require some sort of DPP review, but I think if the concept that we're agreeable to granting that space, I think that we are perfectly empowered to be able to reach that type of an agreement ourselves.
So just to summarize, my understanding is you're saying that you're anticipating that it would take 2 weeks for your engineers to determine whether the solution proposed by Ho'ohana is acceptable and would avoid any further objections to this, to their particular motion. Is that correct?
Yes.
All right.
Yes.
Thank you. Thank you.
Thank you, Commissioner Chang. Commissioners, are there further questions right now for Ms. Tam? If not, I have some. Any questions, commissioners? Ms. Tam, are you familiar with condition 23 of the original decision and order in this matter?
I'm sorry, I don't know offhand. Is that a release of conditions?
No, it is you are bound by all representations made by the developer.
I'm familiar with that type of requirement, but I don't know the exact language offhand.
Did you, in your due diligence, review all the transcripts from the original hearing entitling this parcel to know what those representations were?
I did read through the record for the findings of facts and the conclusions of laws and decision and order. I did not go through actual meeting transcripts, no.
Okay. I'm now going to ask you a question that is like impossible for you to answer. Do you know what my favorite thing about this entire docket is? My favorite thing about this docket is that the LUC is constantly being kicked around the Capitol as the excuse for why we have no affordable housing in Hawaii. And this docket is the awesome example of even when we entitle stuff, other parties can completely screw up and cause no housing to be occurring. So I'm very glad that you guys are actually working towards finally getting housing occurring. It's not our fault it hasn't occurred to now. My final question is, when are you going to actually come to us with an update on what started when I was 2 years out of college? And I can assure you, I am far from 2 years out of college now. When are you coming back to us with an actual plan?
Well, we did just close the middle of August, sir. We're in the middle of making sure we deal with all of the updates, the infrastructure master plans to be reflected properly in our project. We hope to be able to come back. If you would like us to show you what the latest conceptual plan is, I'm happy to do that. I would think I'd be able to do that in the coming months. I can't
think that would
commit
be
to
a very,
precise
very
date.
good idea, that especially as, again, this commission, which works very hard, is continually accused as being the problem with the lack of affordable housing in Hawaii. We're not. This is a great example of it. You guys need to step up and figure out how you're going to get this done and show to us so that we can respond to people. I have nothing
I'm trying
further.
very hard to do that, sir. Thank you.
Is there any redirect? Mr. Lau.
No direct, no
Okay.
redirect, Mr. Chairman.
Do you have any final comments during your portion of argument?
No final comments.
Okay. It is 2:05. We are breaking till 2:15. Then we will continue with any statements by the city and county and the Office of Planning.
Maybe subject to an update. But the problem is, holistically, the city would need to review the big picture overall, because we can't just approve piece green. So we have to look at everything collectively. What complicates the matter is, in addition to that, as the landowners are aware of, the laws have changed. The federal laws have changed. And you have heard that with the Hawaii Memorial proposal with respect to how much water you have to retain on the property, what is allowed to enter the drainage system. So those are all things that was not accounted for in a 95 plan, but those are the additional steps that the landowners would have to do to ensure compliance with federal requirements. So those are all things that will be confirmed when these projects move forward. But at this point in time, for the department or the city to say, this is exactly what is needed, we wouldn't be able to do that because we don't know exactly what is being proposed and the details as to what is being constructed and how they're going to accommodate it. If it's going to be a detention basin or other type of methods in accommodating the flow.
Thank you, Mr. Takahashi. Just one last question. Assuming that Haseko and Ho'ohana come to some kind of a resolution, so they have, you know, they reach an agreement, but Ho'ohana comes in for their permit, and you are reviewing it in light of, as you say, holistically, all the other projects around there, and you're looking at it in a very objective way. Notwithstanding the agreement by Ho'ohana and Haseko, could the city find that the drainage is not consistent with the master plan?
There is always a possibility, but what that agreement would put forward is the responsibility as to who will be constructing which portion of the improvements, how it will be handled. They would need to maybe do some slight modifications to address different standard requirements imposed, for example, by the federal government because of NPDES. So there's always a possibility, but again, what that agreement also helps, and it's not really specifically related to this, is that if we have some type of phasing of assurances as to who's going to do what and when, there is a possibility that the city will be able to support a phase approval. Because yes, they may not be able to accommodate ultimate capacity at that point in time, but because of the agreement of who's going to be building what, then we know, okay, at least this increment we can allow to move forward. And those are things that property owners will like, that type of assurances, because they're putting forward a lot of investment capital just to have that assurance to say, okay, we need to start. We know we can't build everything one time, but let's see what we can do in a timely manner and plan everything out and schedule it. So those are all things that holistically we look at and see, okay, do we have enough information to conclude that this project can proceed in a safe manner?
Very helpful. So, Mr. Takahashi, it would be wise for Haseko and Ho'ohana to consider these kinds of considerations that you just talked about as they review these plans together, that they are taking into consideration the federal requirements as well as all of those things that you just mentioned. You would agree that that would be wise on their part for purposes of minimizing unnecessary expenses. Would you agree?
Correct.
Okay. Okay. Thank you so very much. You've been very helpful, Mr. Takahashi. Mr. Chair, I have no other questions.
Thank you, Commissioner Wong. Commissioner Axon, followed by Commissioner Ohigashi, followed by Commissioner Wong.
Chair, that was Commissioner Chang. Mr. Wong.
I'm sorry.
Mr. Chair.
Yeah, sorry, but you had raised your hand earlier, Commissioner Axon.
Yeah, that's correct. But well, I'm also with Commissioner Chang, that I'm hoping that the two parties can come together and come to a resolution without, you know, getting into any litigation and delaying whatever projects they have. My question to Mr. Takahashi, allow Mr. Takahashi, is when you are reviewing this the permit, if the thing comes to you, you are not necessarily looking into the compliance of with the original drainage master plan.
We are required to, because everything, I hate to say, water flows downhill. So whatever we improve in one area will have an effect on another area. So we have to look holistically with respect to how everything is tied in together. So we are looking with respect to how it relates to a regional drainage master plan, correct?
Yeah, because I thought I heard you that, you know, you are basing your approval based on other projects and also the current situation of the land.
I'm sorry, not exactly clear your question, but what we do is based upon what we feel is a safe amount of water that can be accommodated under the current drainage infrastructure that is in place at that time. So respect to timing, everything has to be coordinated and timed together, in which we have to make sure that we
If I may,
have.
Mr. Takahashi, do you want to restate your question, Commissioner Axon?
I'm just trying to figure out if this, drainage master plan is still good or is obsolete.
The drainage master plan is dated, but respect to immediates require a minimum update. But again, without the details with respect to what is exactly going to be proposed in each one of these developments would affect the amount of water that is being discharged from the site. So those are details we don't have yet. It's at this point, it may be premature for the city to set forth a requirement. We need to do it now, when, for example, HALEKUA, who just acquired the lot, is still developing their master plan and need to see, okay, how much, as a result of this proposal, how much runoffs and we may be generating, and how much can we accommodate on site?
Thank you.
We still need to develop that.
Thank you, Mr. Takahashi.
Understood. Again, I'm hoping that the two parties can come together. And if not, Mr. Takahashi, do you have any recommendation or suggestion for what the commission can do to prevent all those delays and take care of the issue now rather than later?
That is a difficult question because it's not within the jurisdiction of the city. The commission does have a prerogative with respect to what it could desire and request. And at this point, it is up to the commission with respect to how you decide to best proceed with this matter.
Fair enough. Thank you very much, Mr. Takahashi. Thank you, Mr. Chair.
Thank you, Commissioner Axon. Commissioner Ohigashi, followed by Commissioner Wong.
Is there any condition that is preventing you from conducting your review of the drainage system and drainage plan in regard to Ho'ohana?
There is no condition that prohibits us from reviewing any drainage master plan. The problem is we just don't have the information or anything in front of us to review.
Is there any condition that is preventing you from getting that information that you are aware of that the Land Use Commission has on now?
I am not aware of any condition, but again, the information may be incomplete because we just don't have the other bits of the pieces of the puzzle.
Any condition that we can fashion that will get you that information quicker?
That will be, again, something that the commission could explore. Right now, I am not aware of any.
So it sounds like, if I'm wrong, you can correct me. It sounds like this drainage master plan is there. Before you issue permits, they got to make sure any party wanting permits would have to make sure that they meet the terms of the drainage master plan. And procedure set up is so that the department, your department, would be the final say in whether or not proposals meet the drainage master plan. Is that right?
That is correct. The city or the Department of Planning and Permitting will confirm compliance with the drainage master plan, yes.
And there's no condition that you can think of that would increase the information or?
The increase of information may be requested by the department. If the department feels, again, as we have identified, the plan is dated and if proposals has changed, then it may require an update, and then that's when we're going to get additional information and more
And
information.
that's within the DPP's prerogative, isn't that right? Or jurisdiction?
That is, yes, that is part of our process in which we'll need to confirm the adequacy of infrastructure prior to approval of permits.
And those issues have to be meted out before, I would imagine, any type of litigation would take place between the parties. And I know you probably don't know the answer to that, but it's just a comment.
Thank you, Commissioner Higashi. Commissioner Wong.
Thank you, Chair. Mr. Takahashi, when this area that we're talking about it appears like there's multiple landowners, correct?
That is correct.
So I know back then in 1990, whatever that master plan was done, it was pretty much one landowner, so there was only one master plan, correct?
Correct. That was, well, the master plan is still related to the one project.
Okay.
Now you just have multiple landowners involved in one project instead of just HALEKUA development as in mid-90s.
Okay, so the question I have is, because there are multiple landowners, does that mean each landowner have to turn in their own drainage plan?
No, there's only one drainage master plan and they have to work together with respect to getting that plan. They have to work together with respect to complying with that one plan.
But but the rules and regulations says, let's say I do, build a high rise in one area and then another area I have a park. So and it's two owners. They have to work together?
They're all encumbered under the same area under either in this particular case, your petition, or if it is involving a zone change, encumbered under what we call a unilateral agreement area.
Okay, so what if we bifurcate this project?
They still will need to comply as now instead of as a single entity as a party.
Instead of just two different landowners with two different issues, and because they're going to have two different drainage plans.
No, it's one drainage plan, but they all have to comply with that plan.
Okay, that's it. Thank you, Chair. Thank you, Mr. Takahashi.
Further questions, commissioners, for the city and county? Commissioner Chang.
I know, I apologize.
And I called you, I was going to call you last time because you said one question, but it had like 6 parts.
Yeah, you're right. And it was dependent upon his response. But one question. So Mr. Takahashi, when the city reviews, let's say Ho'ohana comes in with their grading and grubbing permit, do you look at whether, for purposes of being consistent with the master drainage plan, in the city's eyes, does it matter whether they are the lessee or they're the landowner?
In the cities, it is considered the condition of requirement runs with the land. So to answer your question, it does not matter if it's a lessee or the landowner.
Okay, very good. No more questions.
Okay, thank you, Commissioner. Commissioners, are there any further questions for the city and county? Mr. Takahashi, do you have any final point you want to make?
No, I don't.
Okay. Office of Planning.
Thank you, Chair. I hope you can hear me.
Yes.
Okay. So we were going to put on 2 of our witnesses, Rodney Furukoshi from Office of Planning.
Oh, you're now fading. I don't know what changed.
Okay, can you hear me now?
It's a little touch and go.
Okay, I'll just yell. So we do have Mr. Furukoshi and Janice Fujimoto from the Department.
Yell louder.
From the Department of Agriculture. but we will just have them available for questioning. So I'd just like to provide our position, and then if the commissioners have questions for myself or either witness, that they are available.
Great, please proceed.
Thank you, Chair. So OP recognizes Ho'ohana's proposed solar project is a worthy project because it will be more productive and efficient than its 2015 solar project and will assist the state in realizing its energy goals. HASECO's plans to develop approximately 1,800 housing units will assist the state in realizing its housing goals. And DOA's agricultural park, which requires off-site infrastructure and the non-potable water line for its operation, will serve to assist the state in realizing its agricultural goals. All three can coexist, and OP is supportive of all three. But unlike this solar project and HASECO's residential development that are on the horizon, the ag park and its associated non-potable water line and off-site infrastructure is a relic of a condition from the original 1993 decision and order. And as with any LUC decision and orders, the Commission should be concerned that this condition has not been fulfilled and has been put off and brushed aside for too long. DOA and the state have waited over 20 years for its fruition, during which agricultural opportunities have been lost. These newly proposed and very promising projects should not move forward without stronger assurances that the ag park will be built. DOA is not asking for anything more or greater than what has already and repeatedly been promised or required. In fact, DOA has conceded more time in conditions A and B because Ho'ohana and HASECO say they can't meet the previously established timelines. We therefore ask that should the Commission approve this motion, the Commission reinstate conditions A and B as we've provided in our revised Exhibit 1 to continue to hold petitioner and the landowners accountable to finally and timely provide the offsite infrastructure and non-potable water line for the long overdue ag park. It should not take another order to show cause for DOA and this Commission to get movement on these conditions. And a couple of additional issues. OP agrees with HASECO that the issue of drainage should be sufficiently addressed by petitioner as required under condition number 16 of the 1996 amended decision and order. OP's revised Exhibit 1 that included our proposed conditions A and B does not include B3, B5, and 7 because we did not alter them, but should be included in the restatement of those conditions. The conditions under condition A as proposed by OP is not applicable to the solar farm development on parcel 52. And the B conditions proposed by OP are applicable only to the solar farm on parcel 52 and shall be applicable only upon development of the solar farm. Thank you. We are available for any questions.
Okay, Commissioners, are there questions for the Office of Planning? If you happen to want to question either Ms. Fujimoto or Mr. Funakoshi, I will also have to make them available for questioning to other parties. Commissioner Chang.
Thank you, Mr. Chair. I do have a question for both Ms. Apuna and then Ms. Fujimoto. Ms. Apuna, the first question is, did I hear you correctly that you said condition A is not applicable to the solar farm?
To Ho'ohana, yes, as lessee. So can I explain further? Because I know that you had questions, Commissioner Chang, about the applicability of condition A and B to the landowners versus a lessee. So even in our position statement, we said that condition A applies to all landowners. That would include, say, for instance, the Robinsons. And I think what we are trying to say is based on a plain reading of conditions A and B under the 2015 order, that is correct, that condition A should apply to all landowners. there have been, I think, some verbal agreements between the parties. And so and there was a commitment made by HALEKUA that they would take care of the offsite infrastructure under condition A. So if a party steps forward and says they will be responsible for that, even though all the other landowners aren't part of that, but they're willing to take on the full responsibility, OP believes that that should be okay.
And so, Ms. Sapuna, are you aware of such an agreement where HALEKUA has absolved the Robinsons, the owner of parcel 52, from the obligations under condition A?
No, I'm not aware of such an agreement.
So with respect to your position that condition A applies to the landowner, I think you just heard Mr. Takahashi with DPP say, when Ho'ohana, or if they come in for a grading and grubbing permit for their solar project, as far as the city's concerned, they don't care whether you're the lessee or the landowner. They're it runs with the land, and parcel 52 has certain obligations. So you heard that testimony from Mr. Takahashi?
Yes.
Okay. So would you agree that that is not, if the city, if that's the city's business practice, Office of Planning, do you have any objections, or would you interfere with their application of that?
No, I don't think we would interfere with their application.
All right. So thank you, Ms. Apuna. So I just have a question for Ms. Fujimoto.
Okay, Ms. Fujimoto, do you swear or affirm the testimony you're about to give us the truth?
Yes. Hi, Janice. This is Dawn. Nice to see you. Thank you for being here this afternoon. I have a question regarding, are you familiar with the condition A1?
I am.
Okay. So do you know who all the landowners are of the petition area?
I fear I'm going to misspeak here. I do know that Robinson, HALEKUA are landowners. I'm not sure of the status of the other surrounding parcels.
Okay. Well, those are the two key owners I wanted to have you confirm. So with respect to the Robinsons, the condition A1 says, refers to a memorandum of understanding with the Department of Agriculture.
Yes.
Have you been part of those discussions regarding the MOU?
I've only been a part of the discussions of the 2020 MOU. The MOUs that came before that were before I was at the department and was not involved in those.
Okay. So my question is, is the owner of parcel 52, the Robinsons, are they a party to this memorandum of understanding?
Not the 2020 MOU. That is just signed between RP2 Ventures and the Department of Agriculture.
Do you know whether they let me ask you this question. Is there any other memorandum other than the memorandum of 2020?
There are previous memorandums before that. And there is a memorandum that we are considering going forward with HALEKUA.
Are you aware of any memorandums involving the Department of Ag and the Robinsons in regards to parcel 52's obligation under condition A1?
No, I am not.
Okay. Is it your understanding that the Robinsons have an obligation under condition A1?
I don't know the answer to that. I do know that the MOU of 2020 is with RP2 Ventures, but I do not know the answer to your question specifically.
Have you reviewed the Office of Planning's amended conditions
Yes,
for condition A and B?
Yes, I have.
Are you comfortable with the proposed amendments?
Yes, I am.
Okay. Thank you very much, Janice. I appreciate your testimony.
Thank you for allowing me to testify.
Thank you. I have no other questions.
Are there any other questions for Ms. Fujimoto, commissioners? If not, I'm going to pause in our questions for OP and see if the parties have any questions for Ms. Fujimoto, starting with the petitioner. Mr. Minot?
Thank you.
Or Ms. Lim? Okay. You guys keep switching off. So.
I know, sorry. Just, I do have one question, and it relates to an Exhibit 34 that we filed. If I could ask Mr. Simon to pull that up, because it's an email from Ms. Fujimoto. And I'm hoping when I show you this email, Ms. Fujimoto, maybe it'll refresh your recollection and you can explain to me what the department's expectation was. If you just move the email down a little bit, Derek, it's an email right there from Ms. Fujimoto to David Tanoe and some other folks. And without belaboring it, you're writing to say that attaches a draft motion for RP2 and HALEKUA to review.
Yes.
And if you would move up move down, go down to the next page. And that the goals of the motion are as stated there: 1, to recognize HALEKUA as a new owner, and 2, to incorporate the 4th MOU into the orders so that the deadlines are incorporated. And this is your understanding. Could you, again, not to belabor the point, but what was your intention with this motion?
The intention of the motion is exactly what it says in the email. It takes that 4th MOU that the department entered into with RP2 and wanted HALEKUA to go before the LUC to recognize themselves as the new owner and to show that that 4th MOU could be incorporated. So the deadlines would be incorporated.
Okay, and Derek, if you would move it up a little bit. My question is, you did, it's in the exhibit. You have a—
Sorry, Ms. Lim, can you help guide me as to where you're trying to go? Because this, what are you trying to confirm?
What I'm trying to confirm is this confusion about the MOU. It's, I guess, 2 points. One, was this motion that's on the 3rd page of this exhibit prepared by the department on behalf of HALEKUA, or was it prepared by HALEKUA? And then 2, when does the department intend to file this motion to have the existing MOU, which is a 2-party agreement between HALEKUA and the department, made, incorporated into the conditions here? Because that's been something it seems like it keeps on coming up in questions. So those are my 2 questions, Ms. Fujimoto. Who prepared it, and when does you expect this motion to get filed?
So this email that I sent, this draft motion to David Tanoe, was prepared by our Deputy Attorney General. Since we are not a party, we cannot file a motion to it. But because it was our expectation that we wanted HALEKUA to file the MOU with the LUC, we were providing this as, I guess, the mechanism that we thought would make that happen. So I'm not an attorney. I'm getting all these terminologies mixed up.
That's fine. That's fine. So is it your expectation that this motion is still going to be filed?
No, it is not, because we are negotiating a new MOU with HALEKUA.
Okay. Thank you, Ms. Fujimoto. That's actually cleared up the question I had.
Anything further, Ms. Lim?
Not for me. Thank you.
Any questions from HALEKUA for Ms. Fujimoto?
Good afternoon, Mr. Chairman. I'm not sure if the question should be directed to Ms. Fujimoto or Mr. Funakoshi, but I can raise the question.
You're allowed to ask a question of Ms. Fujimoto right now.
Okay. And if she doesn't know, then perhaps I'll be able to ask Mr. Funakoshi. This is regarding revised Exhibit 1. Ms. Fujimoto, in the language of Condition A, it talks about the landowner and with the plural S in there. basically shall enter into a memorandum of understanding. Is it the intent of the Department of Agriculture to only have HALEKUA sign this agreement, or would it also include the rest of the landowners from within the petition area? That would include HRT Realty and Robinson Trust.
I believe that is carryover language from the previous condition. So I will defer to LUC, to OP on that issue.
Okay. Second question I have is, there's a proposed new condition A6. It says failure of solar project. And if I may read this because it's fairly short. It says, should Ho'ohana fail to construct and complete the solar project, the easements, construction, maintenance, and costs of the non-potable water line described under condition B1 shall revert to the responsibility and expense of the landowners. Are you familiar with this particular condition?
I have read it, yes.
Yes. Again, so this condition would come into play if the solar project were not to proceed. Is that correct?
That is my understanding.
Okay.
If they do not comply with B1.
Okay.
As it's
And, I'm sorry, go
All right.
ahead.
Yeah.
Now,
Sorry, Mr. Lau, same question I had for Ms. Lim. What are you trying to determine?
I'm just trying to, because potentially HALEKUA would be responsible for this condition, so I'm trying to understand the full scope of the condition.
Okay, if you can
Okay.
do so quickly.
I think it is as it's stated there. I actually don't think it's a significant deviation from the A1 condition back in 2015, where if the solar farm didn't come to fruition, it went back to the landowners. I think it's a very similar condition.
Okay. So the condition that this looks like it's a holdover from is, it sounds like all the terms in, that were applicable to condition B1. Is that correct?
I'm sorry, can you repeat your question?
So this looks like this is a contingent condition that should the solar project not go forward, essentially all of the terms and conditions in this proposed condition A6 are carried forward from condition B1. And in particular, I'm focused on the word maintenance because this condition was not the condition to maintain the water line infrastructure was really not a condition that was previously imposed upon landowners under A1, correct?
That's true.
And so we would, as a landowner, HALEKUA would contingently be liable for this maintenance condition if solar project didn't move forward.
It appears to be possible, yes.
Okay.
Anything further, Mr. Lau?
I have no further questions for Ms. Fujimoto. Thank you very much.
Okay. Does the city have any questions for Ms. Lau?
Sorry, 2 mute buttons. Sorry, we do not have any questions.
Okay. Okay, we're back to the questioning of the Office of Planning on their position statement by the commissioners. Commissioners, any further questions for Ms. Takeuchi Apuna? Going once? Going twice? Okay. It's 2:56 p.m. We need to wrap up by no later than 4:15 p.m., perhaps earlier. I want to take a break until 3:10. When we come back, I will give the commissioners a chance to ask any final questions. A limited chance to ask any final questions of any of the parties. I'm even willing to give the parties like a very brief, like 2 minutes to present any final thoughts before that? And if that is done, then go into deliberation. Not acceptable, parties? Petitioner?
Yes,
Yes, sir. Acceptable to petitioner.
acceptable to Haseko.
County?
Yes,
Please,
acceptable.
Miss,
Yes.
okay, thumbs up. Great. Okay, we will reconvene at 3:10. Questions?
Chair,
Start, yes.
could you please check whether the court reporter is there?
Ms. McManus?
Yes, I'm here. Thank you.
Okay,
Thank you.
thanks. We do have a psychic bond after these many years, so I kind of knew she was there. But good to check. Okay, starting with Ms. Lim, will it be you closing?
Yes, Chair, thank you.
Okay, you have 2 minutes. Go for it.
Okay, I'll keep my eye on the clock. Thank you, Chair. Thank you, Commissioners, for listening to us and reading through all of our materials. You heard what we're asking. We're asking that the Commission authorize an extension of time so that we can build a 52 megawatt solar project on property that is totally within the urban district. It is a solar project that will contribute greatly to the state's renewable energy goals. There are no other immediate plans to develop this property. By the time that the solar project is finished and decommissioned, the property will then be available for the third increment of development of Royal Kenia Phase 2. Some of the issues that we talked about today and yesterday included this MOU and what are the conditions that are going to be applicable to the landowners versus what are the conditions that are going to be applicable to the solar farm. So as you know, some of the things that Office of Planning had written in its initial response, we had issue with. But yesterday, the Office of Planning filed revised Exhibit 1, listing out conditions A1 through A6 and conditions B1 through B6. And then as Ms. Apuna said, there's a couple of other conditions that they would take from the 2015 order and put into the B conditions as well. And we had a bit of a question about them, but Ms. Apuna clarified it today when she did confirm that the B conditions apply only to the solar farm and only upon development of the solar farm, and the A conditions do not apply to the development of the solar farm. And with that clarification, we understand that Ho'ohana is agreeing to build the non-potable water line and only the non-potable water line. But we're very happy for the department, for the Office of Planning support and find these conditions completely acceptable. The other outstanding
2 minutes.
Is that 2 now?
Yes. You want to conclude?
Oh. If I could, the other outstanding issue, thank you, Chair, is this drainage matter. This drainage matter there is something that can be worked out to the extent it needs to be worked out through the city permitting process. This is not an issue for the Land Use Commission. The same way in January 2015, the Land Use Commission approved the solar farm originally. We're here to get a minor amendment to that original approval. To the extent that there's any city issues that need to be resolved, they can be resolved as we continue the city permitting process. So we would ask that the Commission please not delay taking action on this very important solar motion. And with that, I will conclude. Thank you very much.
Thank you, Ms. Lim. Is it Mr. Chung or Mr. Lau?
It will be me.
Thank you, Mr. Lau. Please proceed.
Thank you. First of all, I want to thank the Commission for taking the time to allow us to present our position. A couple points we want to make. We really think it's important that the drainage master plan be followed and complied with by Ho'ohana Solar. The matter is ripe for resolution because Mr. Green, Ho'ohana's witness, indicated they do not intend to comply with the 1996 drainage master plan. However, I am encouraged that the parties could still work out a resolution, and we're hopeful that they will follow through with what they have indicated they're willing to do. With respect to the conditions that the OP has proposed, I had asked some questions of Ms. Fujimoto, and the one that we were focused on was the contingent responsibility to maintain the water line and the appurtenances should the solar project not be completed. The reason we're concerned is HALEKUA's development will probably last 10 years. Once HALEKUA is gone, there's nobody there except for the homeowners association. I don't think that's a burden we want to place on the homeowners association, because this is probably going to be a project made up of affordable housing and workforce housing. And there should be no reason why homeowners should be burdened with something that occurs on a state parcel. And so conceptually, we don't want that condition of maintenance being placed, even though it's a contingent obligation. I think that from our standpoint, that's really the issues. Thank you very much.
Thank you, Mr. Lau. Mr. Takahashi. Mr. Takahashi?
Sorry, it's an unmute problem again. I apologize. Yes. City does not have anything else to offer.
Okay, thank you. Ms. Takeuchi Apuna.
Thank you, Chair. We would just like to address the issue that Mr. Lau brought up as far as the condition requiring the fallback condition requiring maintenance of all the landowners. The intent there is just to make sure that should the solar project not be completed, which we're hoping it will, but should it not, that the responsibility of the water line and its maintenance will still, under a condition, be provided by all the landowners. So we don't intend that it's necessarily a specific landowner, but that if the solar project fails, if we don't include maintenance in that condition, then we're not sure who. There is no party or specified to be responsible for that maintenance. So that's the intention for that specific condition. Thank you.
Okay, thank you, Ms. Apuna. Commissioners, when we go into deliberation, we will also, if necessary, I will allow you to ask very specific questions of individual parties, but I want to make it available to you before we enter formal deliberation if you have any final questions of any of the parties on this docket. And I would ask you that only that for the interest of time, you limit it to the council rather than any of the witnesses. Are there any questions, commissioners, before we enter into deliberation? Commissioner Wong.
Thank you, Chair. This is for Ms. Lim. Ms. Lim, again, just wanted to reaffirm what you just stated about the OP issue. And you guys are agreeable to A1 through 6 and B1 through 6, is that correct?
Yes, Commissioner Wong. OP confirmed that the conditions A1 through 6 do not apply to the development of the solar farm. I'm here to represent Ho'ohana as the developer of the solar farm. So these conditions, A1 through A6, are not applicable to the development of the solar farm. Therefore, I really don't have a position on these conditions. Okay. Whereas the B conditions she confirmed are intended to be the conditions that apply to the solar farm and apply only if the solar farm gets developed. And I represent the solar farm developer, and we stand by our commitment to comply with those conditions.
Okay. Thank you, Ms. Lim. I just wanted to reaffirm that. Chair, after everyone deliberate, I would like to make a motion, so I'll yield my time so I can make a motion after that.
Okay. Are there any further questions for any of the parties at this time, commissioners? Commissioner Axon.
Thank you, Mr. Chair. I just want to.
And then Commissioner Cabral.
So if both parties are committed to continue a good faith effort on trying to resolve this drainage master plan issue.
The question is, are both parties, presumably meaning the petitioner and HALEKUA, willing to continue good faith efforts to resolve the drainage plan issue, starting with Ms. Lim and then Mr. Lau or Mr. Chung?
Thank you. Um, Petitioner, as I believe Mr. Lau, or maybe it was Ms. Tam indicated, petitioner has communicated with HALEKUA to indicate is there potential? Can we do something to adjust the solar panels? Please keep in mind, petitioner doesn't own the property. There is no easement in favor of HALEKUA on the property. So our ability is limited to our ability to seek ways of modifying the solar panels, or maybe there's other solutions. There have been efforts to talk. I mean, and I have every reason to think that those efforts can be ongoing. I cannot commit to a specific result, but certainly Ho'ohana has tried to talk with HALEKUA, and I have every belief that they will continue to try to talk with HALEKUA.
Thank you.
Did that
HALEKUA?
respond?
HALEKUA?
We are pledging to work in good faith with Ho'ohana Solar, and we're hope to wrap things up, in the 2 to 3 week period that we need to evaluate through the engineers a workable solution. And then the hard part is the lawyers will just have to document the agreement.
Okay, Commissioner Cabral. Sorry, actually, sorry, Commissioner Axon, was your question answered?
Yes.
Thank you. Commissioner Cabral.
Yes, thank you. Actually, this is directed, I think, at Attorney Lau. I'm not sure if I heard or misunderstood. In your comments about maintenance of the water line, you commented on not wanting to burden the residential homeowners that would be potentially lower income residents with the maintenance of the water line. Are you specifically referring to the maintenance of the water line that would be servicing the solar farm, or are you talking about wanting to have the solar farm be responsible for the maintenance of a primary line that would be benefiting the housing projects?
Please clarify, Mr. Lau.
Okay, the comments that I made in my closing statement specifically relates to proposed condition A6, which basically says that in the event solar project does not proceed forward, that the landowners will be responsible for the development, construction, and maintenance of the non-potable water line from, which I believe is Reservoir 225 to the State Ag Park. And so my comment was the previous condition that applied to the solar company was that for the duration of their land lease or the duration of their operation, they would maintain the water line. So our comment was that, when HALEKUA completes its development, which should take about 10 years, there's nobody behind us. And if it means that the homeowners association being the successor of the development, it would be unfair to penalize them with having to pay a maintenance fee towards the water line when it has no benefit to them.
Thank you, but I think that is potentially an issue since the property is all one large property with those conditions. But you clarified quite a bit of my concern there, but I think there still is potential problem if things don't go perfect along the way. Thank you.
Okay. Thank you, Commissioner Cabral. Are there any further questions from the commissioners at this time? Otherwise, I'm going to ask to start into formal deliberation. I know that the record will show that all of the commissioners except Lee Ohigashi were present for the entirety of these proceedings. Commissioner Ohigashi was absent for the brief cross-examination of Mr. Overton, who was testifying for the petitioner. Just for the record, Mr. Ohigashi, can you again affirm that you've listened to the recording of this morning's cross-examination and you're prepared to deliberate on this matter? You're muted. Commissioner Ohigashi, you're muted.
I'm sorry. Yes, during the lunch break, I was able to review or listen to the recording of the cross-examination of Mr. Overton, heard Nancy,
Okay.
and heard Edwin, but and I'm ready to participate.
Okay, commissioners, what is your pleasure? Commissioner Wong, had you indicated a desire to make a motion when it was time?
Yes, Chair, thank you. I would like to make a motion to approve the proposed changes by Ho'ohana Solar in its, and that all the changes Ho'ohana agreed to that OP suggested. So I guess that's B1 through 6. That's applicable to them, that they agreed to.
There's a motion before us by Commissioner Wong. Is there a second? Seconded by Commissioner Ohigashi. Commissioners, we are now in discussion. Commissioner, normally, so I see a number of hands. Commissioner Wong, do you wish to speak to the motion, followed by Commissioners Chang and Giovanni and Ohigashi? Commissioner Wong, you're muted.
Yes, Chair, thank you. So it's, I want to say that was a lot of discussions about everything from water lines to the drainage and all that. But I guess the main thing right now is what the Movant has requested. So that's why I want to just say, let's move on and then work. Hopefully everyone can work together to get something done. That's it. Thank you, Chair.
Thank you, Commissioner Wong. Commissioner Chang.
Thank you, Mr. Chair. I just wanted a clarification from Commissioner Wong. Is your motion only to adopt OP's proposed revisions to condition B? Are you also including condition A that was included in their revised Exhibit 1?
Well, I guess Ms. Lim said that it's not applicable to them, but I'm open to that if, you know, we have to put it in, but if it's because it's not applicable, I figure we don't need to put it. So I'm unsure on that one.
Okay. My request would be that you would reconsider and include condition A, because it does apply to the off-site infrastructure, clarifies it, provides a new extended deadline, as well as it addresses the condition number 6 if the solar farm does not proceed forward. So there is some applicable provisions as a contingency. So that would be my request, that you consider amending your motion to include all of OP's conditions A and B.
Commissioner Wong.
Yeah, so I guess I will consider it a friendly amendment that I will agree upon and ask Commissioner Ohigashi if he's approving that too.
No objections. No objections.
Okay. Okay. Anything further, Commissioner Chang? Okay. Commissioner Ohigashi, followed by Commissioner Giovanni.
I want to speak directly about this, the drainage plan issue. And I look at the development as being all connected together. And because it's all connected together, a delay or a forced delay on one would force the delay on the other. And rather than speaking about lawsuits, things that will obviously delay 2, or even, I guess, it would be 3 good projects, we should take a look at utilizing the DPP or the county, city and county's mechanism of trying to figure out what the drainage should be in that area. And all of you are related or connected to each other because of this project. So if you don't agree on a drainage plan, none of you will get permits. And that just doesn't make sense. So I leave it up to you for the people of Honolulu and Hawaii to develop the energy that we need and the housing that we need. And I think that would go much further than us putting any kind of specific conditions, reaffirming that somebody made a mistake or somebody needs to comply or they're in non-compliance. And that's why I'm supporting this motion.
Thank you, Commissioner Ohigashi. Commissioner Giovanni, followed by Commissioner Okuda, and then Axon. Sorry if when you raise your physical hand instead of the electronic hand, I sometimes miss the order. I apologize. Commissioner Giovanni.
Thank you, Chair. So I'm generally favorably inclined to support this motion. However, I have lingering concern about potential for abandonment of the solar farm for up to 18 years in the event they don't get an extension or a new power purchase agreement beyond the one they already have. So I'd like to propose a friendly amendment, another friendly amendment, and it would go as follows. In the event that the project owner fails to secure a PUC approved extension to the PPA or a new PUC approved PPA by December 31st, 2045, the project owner would immediately commence with decommissioning of the solar farm as described in condition B7 of the petitioner's motion and complete the decommissioning by December 31st, 2047.
Commissioner Giovanni, before I ask whether the movant and the seconder are agreeable to such motion, I just want to check, do you believe that particularly in your questioning of Mr. Green, there was sufficient information in the record to establish findings of fact supportive of such a condition?
I do. I think he represented the art and the practice in the industry today, but 20 years from now, things could be a lot different. And the attainment of a PUC approved extension or a PUC approved power purchase agreement, just as though they thought they had one in 2015 and it didn't materialize, that could happen. So I accept at face value from the petitioner and from Mr. Green that they indeed plan to extend, but there's no guarantee, just as he said, there's no guarantee. And in the event they fail, give them up to 2.5 years to be successful, then we'd start the decommissioning, which is pretty much what he said would happen when I asked him about it. So I just wanted to formalize it.
Thank you. Is the movant and the seconder are agreeable to the modification of the main motion?
With all due respect to the Commissioner Giovanni, because we really didn't have time to discuss this in detail with all parties, I can't agree to this. If it was during the deliberation, during the whole portion, then I would say yes. But at this point in time, to me, it's too late in the game. So I would say, sorry, Commissioner, but I would not agree to this.
I don't think my comment is necessary, but Commissioner Giovanni can make it form a formal motion and amend the.
Yes, another Commissioner Wong, would your objection, I have no idea what they will say, but would your objection to amending the motion be resolved if the petitioner indicated a willingness to accept said condition?
No, because right now, I would
That's
tell
fine.
you. Okay, thank you.
So, okay, so procedurally, Commissioner Giovanni, you've asked for this amendment, and the Movant declined to make such an amendment. Do you have further to say on this matter at this time?
What's my options? My options is Commissioner Ohigashi indicated. Can I make a formal motion?
So, okay, here's where I'm going to be I'm going to try and talk this through the way I think we're supposed to do this.
Okay.
Right. I think that we now continue on debate of the main motion, and your option would be to vote against the main motion and convince enough other commissioners to vote against that motion. And if that motion fails, then provide a motion that contains the provision that you would like.
Okay.
The Attorney General can interrupt me if I'm getting my procedures incorrect. You're muted.
You could do it either way. You could have both motions on the table for discussion simultaneously, or you could handle them seriatim.
Okay, if I had them both simultaneously, then what order do we consider them in?
You would consider them in the order that they were made.
Okay. Okay, Commissioner Giovanni, do you want to make a motion?
I do. I'd like to make a motion that which is identical to the one that's on the floor currently, that has been made by Commissioner Wong and seconded by Commissioner Ohigashi, and add the additional condition that I added about restoration and decommissioning of the property in the event that the project owners fail to get an extension to their power purchase agreement.
Is there a seconder to what I shall refer to as the Giovanni motion? Commissioner Okuda.
Thank you, Mr. Chair. I'll second that motion.
Okay. We have two motions before us. This is new and different, but I think given the experience of this docket the last 2 days, it's not surprising. Commissioners may speak to either or both motions. Commissioner Okuda, you had your hand up before, and then Commissioner Axon, followed by Commissioner Chang.
Yeah, thank you, Mr. Chair. I'd like to speak in favor of this motion. First of all, I believe—
The Giovanni motion?
Yes, in favor of the Giovanni motion. I believe there is sufficient evidence in the record based on the testimony about the possibility that there may not be a renewal for a number of reasons, many unforeseeable, of a power purchase agreement. So I believe that what the Giovanni motion does is, take that into account. So there is sufficient evidence in the record to support that. As to the rest of the motion, I believe whether it's the Wong motion or the Giovanni motion, since those are basically identical, I believe the record is very clear as far as why the petitioner's request should be granted. If I may just read one very short thing, because I really believe what speaks in favor of the petitioner's project is really Article 11, Section 1 of the Constitution, which says, "For the benefit of present and future generations, the state and its political subdivisions shall conserve and protect Hawaii's natural beauty and all natural resources, including land, water, air, minerals, and energy sources, and shall promote the development and utilization of these resources in a manner consistent with their conservation and in furtherance of the self-sufficiency of the state." This project fits squarely within the constitutional mandate, which for many decades has not been followed, but fortunately now people have a commitment to do so. But I believe the Giovanni motion takes into account the potential that there might be this future potential abandonment or inability to extend the power purchase agreement. So for those reasons, and with all respect to Commissioner Wong, I would ask that the Giovanni motion be supported. Thank you.
Thank you, Commissioner Okuda. Commissioner Axon, followed by Commissioner Chang. Well, actually, Commissioner Axon, and then since Commissioner Chang has spoken already, I want to give space to any commissioners who have not yet spoken. Commissioner Axon.
Thank you, Mr. Chair. My intention is to speak about the original motion by Commissioner Wong, but let me take care of Commissioner Giovanni's motion first. I intend to vote against it for the reason what Commissioner Wong stated earlier. We don't really have that much discussion on this one. So that was, I plan to vote against it. On the Commissioner Wong's motion, we're talking about sustainability. We're talking about employment, and we're talking about housing. And these are areas that, you know, state of Hawaii needed, and also I believe that was, that's Land Use Commission's mission. So having said that, you know, I have to vote yes for the, on this motion, but I'm hoping that, you know, I said earlier that all parties can get together, make a good faith effort to reach an agreement among themselves to avoid very expensive expenditures for all parties. And I'm hoping the Department of Planning, Permitting, do their due diligence to make sure everybody is protected on this one, and also enforce what is needed to be enforced. Thank you, Mr. Chair.
Thank you, Commissioner Axon. Giving space to commissioners who have not yet spoken before Commissioner Chang, Commissioner Cabral. Sorry, you're muted. Commissioner Cabral, do you wish to speak or no?
I'm
not at this time.
It's Nancy. Sorry. Yeah, I'm trying to work my brain through these different options. I can appreciate both options, but
that's fine.
I'm thinking about it, but I don't have any questions at this time.
Commissioner Chang.
Appreciate our commissioners, though, that think of all these finite details of what would happen if something goes wrong. So thank you.
Commissioner Chang. Thank you for your patience.
Thank you, Mr. Chair. I support Commissioner Giovanni's motion. I think there has been adequate discussion in the record, both through Mr. Green. I mean, we actually did a truncated hearing process. There probably could have been a lot more testimony provided on that. Office of Planning's proposed revision exhibit, their exhibit, condition B7 specifically deals with decommissioning. So in addition to Commissioner Okuda's recitation of the Constitution, I think many of us have seen what happens when you have abandoned structures. There are abandoned windmills, abandoned solar farms all over the state. And that's what happens. I mean, I would have gone even further and required a bond in an escrow account to cover the decommissioning. Because what we have seen is these industrial plants that have not cleaned up their opala after they are piled. So I am going to support Commissioner Giovanni's motion. I just want to clarify that Commissioner Giovanni's motion also included my friendly amendment, which was to include condition A's as part of OP's their proposed exhibit.
Yes, that's correct.
All right,
Okay.
thank you.
And Commissioner Chang, I want to make something, because you brought up condition B7 regarding, sorry, did somebody say something? Commissioner Chang, you brought up condition B7. I want to make sure that the original motion of Commissioner Wong included condition B7 as well, which was not in Exhibit 1, but stated orally was a sought condition by OP today.
You could check the record, but I did not hear B7 in the original motion.
Yeah, okay.
Same here, Chair. This is Commissioner Wong. I don't know what it was B7. So if Commissioner Chang can either tell us where it is or explain to us, please.
Actually, for the limited purposes of responding to this, I'm going to ask the Office of Planning to speak right now during our deliberation and explain.
Oh, thank you, Chair. So we have our exhibit, revised Exhibit 1, and it speaks to certain B1. There's B1, B2, B4, and 6 that we provided edits to or alterations, but we also would like to include B3, B5, and B7 that are in the 2015 order. Thank you, Chair.
Okay, so Commissioner Wong, is your intention to clarify, and that was orally stated, I recall Ms. Apuna stating that during our proceedings today. So when there was a discussion of an adoption of OP's recommendations, is that your intention, or is it for the more narrow list of conditions in amended Exhibit 1?
Okay, so when I was going through this with the petitioner, I thought it was only with A1 through 6 and B1 through 6, and that's why I made that motion. So I would like to ask, if you don't mind, the petitioner, if they're okay with that B7.
Ms. Lim?
Thank you. Thank you, Chair. Thank you, Commissioner, for the question. So B7, we're talking about the decommissioning condition that was imposed in January 2015. As explained in our motion that we filed in August, petitioner would adhere to that condition, B7, the decommissioning condition.
Thank you, Ms. Lim. So, Mr. Wong?
I have no, I have no problem with that as a
As okay, I'm going to treat it as a friendly amendment, so I'm going to have to ask this 4 times. Commissioner Ohigashi, are you okay with the amendment to the Wong motion?
No objection.
Okay, Commissioner Giovanni, are you willing to accept that as an amendment to your motion?
Actually, my motion already includes it because I referenced B7 in my, that is the amendment I'm asking.
Okay.
It's not
Okay,
needed.
so then that being said, where we're at is now the 2 motions are identical with the exception of your additional language. Commissioner Giovanni, is that correct?
I believe that's correct.
Okay, you have your hand raised, Commissioner Giovanni.
Thank you, Chair. So, and I just want to, I have every confidence that the solar farm is going to be built. In fact, I have a lot more confidence it will be built than any affordable housing or workforce housing. I think it's going forward, and I think it's going to be great for the community of Oahu and for helping the state achieve its state energy goals. My only concern is what Commissioner Chang raised about abandoned infrastructure where developers walk away from a project even when there's language that says otherwise in their permits. So in my motion, I've included a timeline that basically said that in the event that they do not get an extension or a new PPA beyond the one they already have in hand, that they don't have 18 years to figure out if they're going to do the demolition or not. consistent with testimony of Mr. Green, he said that they would need a couple of years to figure out if they're going to have a future or not, and then make a decision. So I added 2 years to the timeline to give them an opportunity to find an extension to the PPA or a new PPA. And then 2 more years to do the demolition under condition B7. And I think it's unlikely that that's going to come into play because I have every hope and confidence that they'll be able to find a PPA extension or a new PPA. But in the event they don't, I think the infrastructure should be removed from the property on a reasonable timeline basis, which I think is 4 years after the close or the termination of the existing PPA. And that's why I put it forward.
Thank you, Commissioner Giovanni. Just so you know, the chair is indicate Commissioner Wong.
Yes, Chair. You know, because I was listening to Commissioner Giovanni and Commissioner Chang, I would withdraw my motion if the MOVAN is agreeable with Commissioner Giovanni's, the petitioner is agreeable with Commissioner Giovanni's changes.
Ms. Lim.
Thank you. I mean, the B7 condition says a solar farm shall be decommissioned following its operational time frame, which I would have interpreted as when the solar farm is no longer operating, it's got to be decommissioned. Even if the LUC were to allow it to be there for 100 years, if that language needs further clarity pursuant to what the commissioner has suggested, then so be it. To me, we're saying the same thing. We're just saying it 2 different ways. While the project is in operation, it's good. And when it's no longer operating, we got to get it out of there.
Mr. Wong, Commissioner Wong, has Ms. Lim's response addressed your concern?
Yes, Chair. And just for once, I was listening to Commissioner Chang and Commissioner Giovanni, so I would like to withdraw my motion and let Commissioner Giovanni's motion be the only motion on living.
Okay. So, sorry.
I refuse to allow it to withdraw. No, I'm like it. I agree.
Okay. So, and I'm going to actually ask before we take a vote, I'm going to make sure that we take a brief, not going away recess to make sure that Mr. Oerdinker has a proper motion to read back to us before we take the vote. I was about to state my support for Commissioner Giovanni's amendment. So this is now settled. We now have a motion before us from Commissioner Giovanni, seconded by Commissioner Okuda. Commissioner Okuda.
Thank you, Mr. Chair. Let me just say one thing very quickly, and that's regarding drainage. I am convinced that Mr. Tanoy of RM Towel, who has a long history in planning and service to the community, I believe he is a person of good faith. I believe that people of good faith will work things out. And so that's another reason why I'm supporting this worthy project. Thank you, Mr. Chair.
Thank you. Commissioners, is there further discussion on the Giovanni motion before us? If not, I'll state my support for the motion. I want to address the concerns brought up by HALEKUA on drainage and just add that I do believe there's enough evidence in the record, particularly in the presentations by Mr. Takahashi, that the city has the ability to enforce conditions on drainage, but knowing what that drainage should actually look like is going to depend partially on what HALEKUA is actually proposing and aligning. And I do have great faith in the representations from Ms. Lim and Mr. Lau that discussions will continue to resolve this in a manner that will allow all the projects associated with this original docket to go forward. Commissioner Cabral.
Thank you. I'm going to support this motion, and I would like to further that encouragement of all the attorneys involved to make sure they realize that they have all somehow gotten themselves somewhat in bed with other parties because that they've all purchased into or made an agreement to be part of what was at one time a large pie, and now they all have interest in a smaller piece of it. And so some of the standing that I have to have it my way may not work out. So I really encourage everybody to work this out so we don't have to hear from you folks for a long time to come. Thank you.
Thank you, Commissioner Cabral. To conclude, Commissioner Axon.
A quick one, Mr. Chair. In light of the petitioner's agreement with Commissioner Giovanni's motion, I just kind of want to make sure that everybody has the same information, and the petitioner has the opportunity to chime in on this discussion. I now therefore will support this motion. Thank you.
Okay. Commissioners, I want to get the last word before I call for the vote. So are there any more comments from commissioners? Going once, going twice. I want to recognize a couple things. One is that, well, the chief thing I want to recognize is that what should have become clear to us as we lived through our pandemic, our economic downturn, our civil unrest, our political strife is that what we actually really need in Hawaii is kind of limited. We need housing, we need food, we need utilities, we need water, and we need to get along with each other. And this project actually represents all of these finally after many, many years of fits and starts. So I am putting the faith of the people of Hawaii in the proponents of these projects to make this happen. Mr. Ordenker, are you ready, or do you need a short recess to compose a motion or to recite the motion before us?
Well, Mr. Chair, if you mean a couple of days, yeah, maybe. No, I think I can state what the motion is.
Okay, so there being no further discussion, Mr. Ordenker, please poll the commission.
Mr. Chair, the motion is to approve the proposed changes as contained in Ohana's motion and to incorporate OP's suggested changes as contained in OP's Exhibit 1 and include amendments proposed by Commissioner Giovanni to Condition B7.
Are there any questions from any of the commissioners? Do you understand that this is, Mr. Ordenker has correctly stated the motion? Okay, thank you.
Giovanni.
Aye.
Commissioner Okuda.
Yes.
Commissioner Wong.
Aye.
Commissioner Ohigashi.
Aye.
Commissioner Chang.
Aye.
Commissioner Cabral.
Yes.
Commissioner Axon.
Aye.
Chair Scheuer.
Aye.
Thank you, Mr. Chair. The motion passes unanimously with 8 votes.
Okay. Are there further comments from the commissioners before we close? Commissioner Wong.
Yes, Chair, thank you. Because of all this moving parts and the changes of ownership with RP2 to HALEKUA, and also they stated that they're gonna do a new plan and all that. I would like to direct the staff to work with HALEKUA to do a status, set up a status report for us.
Okay, thank you. Mr. Ordenker, can you please arrange that to?
Thank you, Mr. Chair. We certainly do so.
Anything further, commissioners? Commissioner Cabral? You're just saying goodbye. Okay. Thank you very much to the petitioner, to the Council for HALEKUA, to the City and County of Honolulu and the Office of Planning. And with pleasure and relief, I declare that we have no further business and this meeting is adjourned.
Thank you, commissioners.